my lord. It was arising out of WBC, my lord.
Huh?
It already by your lordship. A order was WBC was disposed of by your lordship.
WPC?
Yes, my lord.
Why WPC you are mentioning here?
My lord, before earlier, 3 months earlier, my lord, and today, for some correction of that order,
Who has passed this order?
my lord,
Who has passed this order?
by
in
your
WPC?
lordship, my lord.
Huh? Which
you-
case? Which case?
Yes, was my lord WBC
Party's name?
party's name, Falani Khatun, and WBC was 1986, my lord, 2026. And for today, my lord, I pray for some correction of that order.
What correction?
My lord, there was 1 biga 3 kata 15 lesser, my lord. And inadvertently, here was in order written as 1 biga 15 lesser, my lord. For this reason, we have filed a IA, my lord, on 5/6 and registered on 8/6, my lord. And I prayed for listing the IA, my lord, on Thursday, my lord, regarding correction, some correction, my lord, that
Thursday?
Thursday, my lord.
Okay. 29, yes. 29, there was a request, BC request. There is a VC request in 29. Then why 2 instructions come? There was a request for VC. We have allowed this. Okay, on the prayer of which item? 29. Mr. A. Goswami, on behalf of Mr. G.C. Gogoi, submits that Mr. Gogoi is out of station and therefore prays for adjournment of the matter. Let the matter be listed after 2 weeks.
My lord, date
After 2 weeks.
my lord, date may be fixed. My lord, I am
After 2 weeks.
Wait, please, Lordship. Lordship, I beg to mention item number 28.
28.
Lordship. Lordship, kindly pass over the matter for the day.
Pass order matter for the
Day.
why?
Lordship, the senior counsel is under sudden medical urgencies.
Okay, on the prayer. Your name?
A. Jubaria, on behalf of S. Hussain.
H. So what is your name?
A. Jubaria.
So and so. Appearing on behalf of Mr. S. Hussain. Appearing on behalf of Mr. S. Hussain. Prays for adjournment of the matter. Let the matter be listed after a week.
Lordship, if possible, kindly be taken up the matter by tomorrow or the day after tomorrow.
After a week. If you take adjournment, then after a week. Yes.
Earlier, your lordship was initially rejected petition, my lord. That was initial stage, well. That is all.
Call for the CD in this case.
Now trial has already commenced. So
Trial is already commenced.
2 witnesses were examined.
Yes.
In the examination chief also, see her statement, if your lordship takes up, her statements are, there are some contradictions, man.
Okay, this is a POXO matter. Will have to issue notice.
Yes.
Heard Mr. P. Kotoki, the learned senior counsel, assisted by so-and-so, the learned counsel, appearing for the accused applicant. Also heard Mr. P. Botaku, the learned APB for the state. This is an application under so-and-so, right? Let notice be issued. Let notice be issued on respondent number 2 through the office, the respondent number 2 as part of prevailing notification of the Gauhati High Court. Notice to respondent number 1 is dispensed with as Mr. Bothako, the learned APP appears in the matter. Call for the raised to call for the TCR in connection with where is this pending?
Pending before the POSCO court, my special judge, POSCO, Kimsagar.
Raised to call for the scan copies of the TCR from the court of the so let the matter be listed. When do you want, let the matter be listed after 2 weeks?
Week.
After 2 weeks.
We are allowed to file some additional affidavit regarding the evidence.
Yes.
Paying for withdrawal item number 3.
Withdrawal.
Yes, ma'am.
You are Mr. B. Islam.
Tip 2.
Item 3, this is item 3. 2 was withdrawn.
Maybe it's lordship. Maybe it's lordship. Lordship,
Which item is this?
item 3 lordship. Lordship, matter relating to POCSO lordship. At this stage, notice may call for upon respondent number 2 lordship. In the meantime,
Okay, same order, right? Only this name. His name is different. Heard Mr.
alum.
A. Alam, the learned counsel, appearing for the accused applicant. Also heard Mr. P. Bothakur, learned APE for the state. This is an application you write. Then you write this notification, notice to respondent number 2. Then as per Gauhati High Court, then you write call for the, this is
Special just POCSO Morigao.
special just POCSO only. Call for the record. Call for the TCR in the instant case from the special judge Morigao. Let the matter be listed after 2 weeks.
Lordship, date may be fixed lordship.
After 2 weeks, date registry will fix.
This is also POCSO case, also. 2 witnesses are already examined, arrested on 2/2.
Okay, I heard Mr. D. Talukdar, the learned senior counsel, assisted by Mr. Sorry. Then the APP you write, same order will go. Which court is this?
Tinsukia. Additional session judge come POCSO Tinsukia.
Additional session judge come POCSO Tinsukia. Others will remain same. Additional session judge POCSO Tinsukia. Let the matter be listed after 2 weeks.
Can a date be fixed?
2 weeks.
Maybe also. Charge sheet case, my lord, section 6 is the section 6 of POCSO Act, my lord.
POCSO.
Yes, my lord.
Okay, heard Mr.
Hey, how are you, my lord?
K.
Hey, how are you?
K. Hawari, the learned counsel, appearing for the accused applicant. P. Bothakur, APP. Then same order, no? This is an application under so and so. Which court?
Additional session judge FTC Dibrugarh, Assam.
Additional session judge in bracket FTC, Dibrugarh, Assam, TCO. Notice. After 2 weeks.
Matter related to POCSO lordship. POCSO lordship matter.
POCSO.
Notice may be issued.
Hmm?
Notice may be issued, lordship. Upon
Your name?
ABT Hawk.
Lord Mr. So and so. Which court?
Lordship, charge sheet has not been filed.
Charge sheet not filed.
Not filed. Bihupuria PS case number 7526.
Call for the CD. Instead of TCR, call for the CD. Others after 2 weeks. Notice to respond number 2 will be there. Same one.
Authorized.
May I please, your lordship? It is a substantial bail application, your lordship. It is a substantial bail application, your lordship. Previous bail application was rejected at the investigation stage by this court, your lordship, on 20/11/2025.
Okay, heard MS so and so, the learned counsel appearing for the accused applicant, also heard.
Now the case is charge
And
sheeted, your lordship. Now the
Yes,
case is
and
charge
so
sheeted.
and so. M. Kakoti, the learned the learned counsel appearing on behalf of Customs Department. We have Customs Department, this is an application under so and so. Then you write call for the CD. No, call for the charge sheet is filed already.
Yes.
In which court?
TCR.
Registry to call for the TCR, scan copy of the TCR from
Additional district and session judge Sri Kasar.
additional district and session judge, Sri Bhumika Sir. Let the matter be fixed after 2 weeks.
Like this lordship. Lordship petition on arrested on 21/4/2026 lordship in connection of Jericho CS number 22 of 12.
I heard Mr. So and so, the learned counsel appearing for the accused applicant. Also heard Mr. P. Bothakur. Even application you write, then call for the CD, let the matter fix after 2 weeks.
My lord, for
2 weeks, after 2 weeks.
my lord, already 83 days, but they are in bar lordship. 83 days lordship.
83 days,
Yes,
charge sheet not filed.
No, lord.
70. 26, 72 days. Okay, let the matter fix in the next week. Next.
Item 9.
May I please, Lordship? Lordship,
Yes, Oxford, tell me.
Lordship is a section under 69.
Hmm.
Succeeded case, the accused is behind the bars for 40 days.
40 days.
40 days.
Okay.
And trial has
Heard
already
Mr.
started.
Swain, heard Mr. Swain, the Learned Counsel appearing. Your name is?
M. Borua.
M. Borua, the Learned Counsel appearing for the accused applicant. Also heard Mr. P. Waterford, Learned AP for the state. There is an application under Swain, so. Then you would write registry to call for the TCR in connection with Cockroach PS case number 79/2026 from the court of the
District and Session Judge Kukrajhar.
district and session judge Cockroach. Let the matter fix after 2 weeks.
Lordship, short date may be given.
After 2 weeks, it will take some time.
10.
Application, 483 application, the second time application, as on that petitioner behind the bar 70 days, 70,
70 days.
70 days. Earlier rejection, that is page 17,
Okay. Heard Mr. So-and-so,
Please
Learned
don't.
Counsel appearing for the accused applicant, also heard P. Waterford. Then this is an application under so-and-so. Charge sheet file? No.
No, Lord.
All for the CD. All for the CD. Let the matter be fixed in the next week.
March on.
All for the CD along with the medical report.
11.
Well, this is a regular bail application, my lord. It was rejected by the learned trial judge. But at page 27.
Okay, we'll call for that, we'll call for the TCR.
Well, at 70.
Foxtrot is there.
71 days, my lord. And the POXO, my lord, 6.
Charge sheet submitted, you are
Correct.
only for 71 days. Don't shout much before the court. You'll have to wait for some time.
I'm not shouting.
Let
my lord,
us,
I'm praying,
let
my
us,
lord.
let us,
But-
let
but
us.
It's a question of personal liberty.
We know about this, Mr. Counsel, we know about this personal liberty. This
the
court is
lordship
taking,
said I am
yeah,
shouting.
wait. This court is taking bail matters, so this court is aware of personal liberties.
Correct.
What I'm saying is that,
I'm
what
not
I'm
disputing.
saying is that simple thing, you have seen the earlier orders that in case of POXO matters, we'll have to issue notice, we'll have to call for the TCR. Without perusing this, you want your bail today only?
May I make submission?
Huh?
my lord?
Yeah, do you need
No,
today
well,
only? So
no, no.
please don't unnecessarily waste the time. See, if you have a lot of time, go to the corridor and argue the case there. But don't shout it here unnecessarily. Heard Mr. B.K. Sen, the Learned Counsel appearing for the accused applicant. Also heard Mr. P. Waterford, the Learned APP for the state. This is an application you write. Then you write, let notice be issued to respondent number 2 through respondent number 2 as per the prevailing notification of the Gauhati High Court. A notice to respondent number 1 is dispensed with as Mr. P. Waterford enters appearance. A registry to call for the TCR, scan copy of the TCR in connection with Fatasi Lambari PS case number 22/2026. Pending before from the court of the special judge POXO, Kamrup Metro. Unnecessary, don't waste time, judicial time. Huh? In the morning only, don't waste time. 2 weeks, let the matter after 2 weeks.
12.
Yes.
Commercial quantity, 183 days behind the bar, my lord. 183 days. my lord.
83 days.
The instruction,
Okay, we'll.
my lord, other two matters arising out of same FIR, my lord. It has been listed before the code number 25, item 41 and 40. You may take the instruction. Yes.
So when can you get the instructions? At 2 we'll take it.
13.
May I please in motion? My lord, 4 numbers of kittens were my lord recovered from my vehicle. I am the The owner, my lord, I have valid Salan, my lord. Salan, I have annexed, my lord.
Heard Mr. S.I. Siddharth, the learned counsel appearing for the accused applicant, also heard Mr. P. Watergo, learned APP for the state. This is an application under so and so. Call for the CD.
Kindly short date, my lord, 38 days.
Let the matter be listed after a week.
40. Obliged.
30 days behind bar, your lordship,
30 days.
30 days. Allegation, your lordship will get the affair is at page 7, your lordship. Allegation is apparently serious in nature, your lordship, but the fact is that your lordship.
We'll
this
call
has-
for the CD
Lord,
and
it's
we'll
an
do-
early date. Your Lordship.
Heard Mr. S. Botago, the learned senior counsel, assisted by so and so, the learned counsel appearing for the accused applicant. Also heard Mr. P. Botago, learned APP for the state. This is an application under so and so. Then you will call for the CD. Let the matter be fixed next week at a date.
Take your blood.
15.
Made, please, your lordship. In this case, section 89 of the BNS has been attracted. Only a short date by BNS CD we called for, your lordship.
Okay, heard Mr. So and so, T.L. Oscott.
T.L.
Oscott, a learned counsel appearing for the accused applicant. Also heard Mr. P.P. Botago, learned APP for the state. This is an application under so and so. Call for the CD. Let the matter be fixed in the next week.
Deeply obliged.
16.
May I plead your lordship? Lordship, in this case, 28 days behind the bar, lordship, and the co was released on bail, lordship, by this honorable high court, lordship. And the FIR is 9.
Is a second bail application,
No, lordship, this is the first bail application, lordship.
but similar matter was
yes.
heard. He is the main accused.
No, he is the prime accused already released on bail, lordship, from Sher Ali.
Hmm?
From Sher Ali was the prime accused, lordship, as per FIR, lordship. He is released on bail. Page 19. Yes, lordship, and 2 lakhs already back to the informant, lordship. He clearly stated.
What is the FIR?
FIR page 9, lordship.
Is
Page 9.
your name is?
My name is Lordship Asadur Haq.
Yes, Mr. Botago. But he is not named also. Hmm? Or his name is there. That this FIR Asadul
Asadul.
Haq. Asadul Haq is
Asadul Haq.
named. He is named.
His name in the FIR, but he's not.
What is his involvement? He will bring a good traditional doctor and he
Yes.
bring Asad. He is the main accused.
No, Lordship, he's not in main accused.
Then who is the main accused?
Main accused is Shamsher Ali, Lordship. Shamsher Ali,
But Asadul Haq is the Kabiraz, right?
Koviras, Lordship.
So he is not the main accused.
And Lordship, sometimes he gives some types of
He-
treatment.
Somebody brings you to somebody's house to treat somebody and you pretended to be a Kabiraz and tried to treat somebody. You are not the main accused.
No, main accused, Lordship. FIR.
Heard Mr. So-and-so, the learned counsel appealing for the accused applicant. Also heard Mr. P. Botago, learned AP for the decision application under so-and-so. Then call for the CD. Let the matter be fixed.
Short date maybe.
Let the matter be fixed on, today is 13th.
Next week.
Let the matter be fixed on 21st July.
Obliged.
17.
Yes, reasonable.
Yes.
Name is not mentioned in the FIR and
Hmm?
specific petitioner name is not mentioned in the FIR, my lordship. No specific role have been attributed to the petitioner.
no overtake and covert.
What about the forwarding report?
The forwarding report in the co-accused, here it is name mentioned, my lordship, in during the transaction, my lordship. My anticipatory bail application.
Yes.
Lordship, with the transaction, so it is a documentary in nature, my lordship.
Hmm?
It is a during the illegal transaction amount money, my lordship.
A ground of
Offense-
arrest it was given, no? Ground
Yes,
of
my lord.
arrest.
Yes, my
Hmm.
lordship. And I will cooperate with the investigation and evidence in electronic and documentary in
Okay,
nature,
this
my lord.
matter we'll have to peruse the case
Yes, my
diary.
lordship, page the FR 18, my lord.
Huh?
FR page 18, my lordship.
Narka, we'll have to peruse the case diary in this case. We will not get any interim relief.
My
Heard
lordship,
Mr. R. Amin, the learned counsel appearing for the
may
accused
I make
applicant.
submission for one?
Also heard Mr. P. Waterpool and APP for the state. This is an application under the writer 482. 482. Call for the CD. Let the matter be fixed on 20th July.
Lordship. April.
18.
Please, Lordship. Lordship, FIR says 13. Matlab, the allegation is that matlab, the accused person with some sharp weapons entered into the house of the informant and assaulted her son Rafiqul Haq and other.
We'll give a short date, but we'll have to see the CD in this case.
My submission is that matlab,
Heard Mr. M. R. Khandakar, the learned counsel appearing for the accused applicant. Accused applicants also heard Mr. P. Waterpool, the learned APE for the state. This is an application under section 482, so and so. Call for the CD, let the matter be fixed on 20th,
20.
20.
19.
My lord, maybe taken after 10 minutes, my lord.
20.
Lordship. And issue notice, your lordship.
Okay, heard MS so and so, the learned counsel appearing for the accused applicant, also heard Mr. P. Waterpool, learned APE for the state. This is an application under so and so. Then you write, let notice be issued on respondent number 2. Through respondent 2 as per the Gauhati High Court notification. Then we write, call for the CD. Let the matter be fixed on Bhattakur when? Hmm? 21st? 21st.
Oblige, your lordship.
22.
Timing, senior is on legs.
Time being
23.
May I please your lordship? Similar anticipatory application 1452/2026 arising out the same FIR has been fixed on 17/7, call for the case diary. So this may be fixed with this.
okay.
1452.
Heard MS so and so, the learned counsel appearing for the accused applicant. Also heard P. Waterpool, that is an application under so and so. The learned counsel submits that another AB application arising out of the same FIR has been listed to be listed on 17th. To be listed on 17th. AB number.
1452.
Let the matter be listed
Oblique
along with the
2026.
AB number, so and so, on 17th. Already called, case diary has been called for in the
Yes,
matter.
lordship.
Please, your lordship. Lordship, POCSO matter, lordship. Lordship may kindly allow us to take steps upon the respondents, lordship. And matter is pending at special judge Hojai, lordship.
Okay, heard Mr. D. Medhi, the learned counsel appearing for the accused applicant, also heard Mr. P. Waterpool and APP. This is an application under section 482, so and so. Then you write, let notice be issued on respondent number 2 as per the Gauhati High Court notice. Okay. This one number 2 and 3. 2 and 3. A registry to call for the TCR in the instant case. The TCR in connection with special POCSO case number 145/2025 from the court of the learned special judge Pujai, Sankardeep Nagar. Let the matter be fixed on 23rd.
Deeply obliged.
26. Wait, please, your lordship. But in this matter, what happened was that after we filed the application matter, during vacation matter, the police has submitted charge sheet. So my prayer is that let the charge sheet be forthcoming.
Okay,
I have done
as
superb.
thus the learned counsel appearing to the accused applicants, also for Mr. P. Protocol and AP for the same, is an application of the so and so. The learned counsel appearing for the accused applicants. Applicants submits that charge sheet in the instant case has already been filed. White, you have number?
Yes,
White
34 of
charge sheet?
26.
Huh?
34 of 26.
White charge sheet number, so and so, so and so.
Dated 29
06. 06, so and so.
in PRC case number 219 of 26.
The history to call for the scan copies. History to call for the scan copy of the TCL. From the court of, which court?
My lord, CGM,
From the court of the CGM,
South Salmara Mankas.
South Salmana Mankasa. Let the matter be listed.
Next week, my lord, if possible.
Let the matter be listed on 21st.
I'll
27. May I please, your lordship? Here is a clash between two groups of cousin brothers, informant, accused, all are cousin brothers, family members. And lordship, in the FIR, specific allegation that he has been assaulted by petitioner number 1 and 2. And lordship, there is no whisper that he has been assaulted by 3 and 4. So my lord, may I pray that Kesdari may be called for and interim may be granted for accused number 3 and 4. I am not praying for 1 and 2 because there is a specific allegation that he 1 and 2 has assaulted him.
What is the FIR?
Yes, lordship. In
Page 11.
Page number 17. May I read, lordship? 70. In Assamese, Barnifus.
Yes.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 21/6/2026 তাৰিখে ৰাতি প্ৰায় 11 মান বজাত মোৰ ভাই নিত্যানন্দ ৰায় বয়স 40 বছৰ লগত পূৰ্ণচন্দ্ৰ ৰায় আৰু জ্যোতি প্ৰসাদ ৰয় ওচৰৰে পেহী ঘৰৰ পৰা নিজ ঘৰত আহি থাকোতে আমাৰ ঘৰৰ সন্মুখত নিত্যানন্দৰ বিষয়ে বেয়া কথা পাতি থকা শুনা পাই ভাইয়ে পদকীয়াজনক দাবী বাধা দিয়াত পদকীয়াজনে
গালিগালাজ আৰম্ভ কৰে আৰু 1 নং পদকীয়াজনে পৰিকল্পিতভাৱে মোৰ ভাইক প্ৰাণে মৰাৰ উদ্দেশ্যে হাতত ৰড লৈ আহি বাকী পদকীয়াজনক লগত মিলি মোৰ ভাইক আক্ৰমণ কৰি মাৰধৰ কৰি গুৰুতৰ জখমপ্ৰাপ্ত কৰে। 2 নং পদকীয়াজনে মোৰ ভাইক প্ৰাণে মাৰি বুলি মূৰত আৰু শৰীৰৰ বিভিন্ন অংগত প্ৰহাৰ কৰা গুৰুতৰভাৱে জখমপ্ৰাপ্ত কৰে। মোৰ ভাইৰ লগত বাকী 2জন ভাইয়ে পদকীয়াজনৰ কথা মতে কোনোমতে আটক কৰি ভাইক ধুবুৰী হস্পিটাললৈ লৈ যায় আৰু তাত ভৰ্তি কৰাই চিকিৎসা কৰাই থকাৰ বাবে এজাহাৰ দিয়াত পলম হ'ল। Here lordship 1 and 2 they are specifically mentioned. So my lord, interim may be kindly granted for 3 and 4 lordship. Let them go, let the CD come, then we'll see. Heard Mr. G. Somo, the learned counsel appearing for the accused applicant, also heard Mr. P. Botapu, learned APP for the state. It is an application under so and so. The case relates to the case relates to filing of an FIR. FIR dated 26.
Yes, lordship.
26/6/2026. FIR was filed by
No
whom?
lordship, no lordship. FIR dated 28/6/2026. But Lordship, but in front it is written, but Lordship, yours faithfully, the last portion, 18, page number 18, it is dated 26/6/2026. There is a confusion, Lordship.
That is 26/6/26 only.
Yes. It is
FIR
right,
dated
26.
26/6/2026. Filed by one Arjun Rai, alleging that alleging that while his brother was coming back, while his brother, namely Nityananda Roy, while coming back from the house of his maternal aunt, the accused persons used certain bad words against his brother, and thereafter a tussle occurred between the accused persons and his brother, wherein the accused number 1 and accused number 2 physically assaulted him using iron rod and thereby causing serious injuries. It was also alleged in the FIR that accused number 2 threatened to kill his brother. It was also stated that with the interference of other persons, his brother was taken to Dhubri Medical College and he is undergoing treatment. On receipt of the FIR, police registered the Gulabganj police case number 146/2026 under section 61 in bracket 2/117 bracket 2/109 bracket 3 109/3 bracket 5 of BNS against the accused applicants. Full stop. The learned counsel appearing for the accused applicants submits that though the accused number 3 and 4 have been mentioned in the FIR, there is no specific allegations against both of them. Therefore, he prays that at least at this stage, the accused number 3 and 4 should be granted the privilege of interim PRS bail. Full stop. After hearing the submission made by the learned counsel appearing for the accused applicants and on perusal of the FIR as well as other materials brought on record along with the bail application, this court is of the considered view that there is a fit case wherein accused number 3 and 4 can be granted the privilege of interim pre-arrest bail. Accordingly, it is directed that in the event of arrest of the accused number 3, namely Harshjit Ray and accused number 4, Nanda Kumar Ray, by the arresting authority in connection with Gulabganj PS case number 146/2026, they shall be released on bail on furnishing of bail bond of ₹20,000, each with surety of like nature, the satisfaction of the arresting authority, subject to the condition that the accused applicants shall appear, that the accused applicant number 3 and 4 shall appear before the investigating officer within a period of 10 days from passing of this order and cooperate with the investigation. Next paragraph. All for the CD. Let the matter be fixed.
CD along with medical report.
CD along with the medical report. Let the matter be listed on 23rd of July.
Highly obliged, man. 19.
Third FIR is at page number 25, my lords.
Well, prior to that, I want to submit that I have received the one summons from the office of the Chief Judicial Magistrate, Kamru Gauhati, Metro Gauhati, asking me to appear in connection with case number RC, page 33.
When?
My lord, this is 2426.
Hmm?
Page 33, my lord. Annexure 6.
Page 36.
33. Annexure 6. Summon is issued by the court of the Chief Judicial Magistrate, Kamru Metro Gauhati, asking me to appear in connection with case.
So that is already over.
My lord.
That is already over.
My lord, I have already appeared in that case.
Hmm.
But thing is this, that if I paid through advocate, my lord,
Hmm.
not personally. Thing is this, my lord, since the case is tabled by Court of Sessions, with section 148, 149, 302 IPC. So I apprehend that in case I appear, then so long the matter is not committed to the court.
What?
I may be-
You are appearing for whom? Senior reason? Leave. Then? What is to be done? What is to be done then? Hmm? It's an AV application. What reply we will require?
My lord, I will appear in the court. My only apprehension that I may not be allowed to go on bail.
When is your
because
senior
of the
coming?
session.
When is your senior coming? 16th. Okay, we'll put it on, we'll put it on 16th.
Okay, my
16th.
My lord, even, my lord, without hearing the counsel for the CBI, because I am not saying that I will not.
No, let us hear them. What is there? 17th, okay. Heard Mr. H.K. Moria, the learned counsel appearing for the accused applicant. Also heard your name? P. Mazumdar on behalf of M. Kumari. M. Kumari, the learned counsel, learned special counsel for CBI. Full stop. MS, what is the name? MS Mazumdar submits that MS M. Kumari is currently on leave and she is expected to be back on 16th and therefore prays for listing of the listing of the matter on 17th. On the 17th, let the matter be listed on 17th of July.
Kindly pass over this matter for time being, madam.
Why?
This leading counsel is coming from the Court of Session, Your Honor.
Who is the counsel?
M. Ahmed. M. Ahmed, Your Honor.
Your name?
Hi.
You are there, you argue. See, this case, I think they have referred this case to I mean, this is regarding section 36, right?
Yeah,
Huh?
Yes, Your Honor.
Section 36 BNS, isn't it? And that is what I'm saying, that there is a reference. So we'll have to wait for this. Okay, that I think I have that number. 1239 of 2026. See, what is happening is that there are some different of opinions about compliance of section 36 if section 48 is complied with. Okay, so therefore the case has been, this issue has been referred to the Chief Justice for placing it before an appropriate division bench for hearing the matter. So we'll have to wait for this, wait for some time. Yes, 1239. Okay, right. Heard Mr. A. Hai, the learned counsel appearing for the accused applicant. Also heard Mr. K. Boyster, the learned K. Boyster, the learned APP for the state. Mr. K. Boyster, the learned counsel, the learned APP submits that the issue relating to uh, mm, the issue relating to compliance of section 36 and 36 and 48 of BNSS has been referred to the Honorable Chief Justice of the Gauhati High Court to place before an appropriate bench in reference by a coordinate bench in bail application number 1239/2026. Therefore, he submits that till the matter is decided by the appropriate bench, the instant bail application instant bail application should be adjourned. Prayer is allowed. Let the matter be listed after how many days? 10 days? 10 days. Let the matter be listed after 10 days. You understood now what has happened? You tell your senior. Okay.
Please allow. Pending for service report matter, POXO case, is perhaps the third day matter.
No, I mean, at least service of whether notice is served or not, that information should be given. Now, how can we do it, Mr. Sharma? If notice is served, somebody is not appearing, that is fine. But you don't have the instruction whether it is served or not. You ask this person to, confirm whether he has served the notice or not. If notice is served and in spite of that he is not appearing, then that is perfectly fine. But if notice is not served, then somebody will come later on and say the notice was not served to us. Okay, heard Mr. S. Nawaz, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the learned APP for the state. Notice in the instant case, service report of service of notice on respondent number 2 is still awaited. Full stop. The learned APP is instructed to is directed to get the instructions as regards the service of notice on respondent number 2. Let the matter be listed when? Let the matter be listed on Monday.
Deep down.
Same thing. Write the same order.
Another chance will be given, probably. We'll take fresh step.
Monday.
Monday.
You want to, no, why fresh steps? You have already taken steps.
Yes, I have taken step.
Let them confirm the same order he pass. Write Mr. S.C. Biswas and B. Sharma. Then the same order will go. Notice not served. Mr. Sharma, you'll have to, you all have to do something because it's on POXO matters, then bail matters, and the service is not being executed. So, somebody has to be specially engaged by them. But for that, like, I think if some letters should be issued from your office saying that this kind of, whatever the difficulties we're getting, and some kind of resolution, because otherwise it takes time, no? Because of things. So at least if they send it to the registry and with a copy to you, please, so that you are aware that whether it is done or not. Otherwise, bail matters are pending. Did you receive? The same order, huh? Same order. Right, Mr. H.A. Ahmed, the learned counsel. No, office note says only this thing. Scan copy received. Nothing else. You have taken steps? Huh? Step is taken on 26/2026, you have taken the steps.
19/6 we have taken.
Okay, we'll wait for this then. Same whatever. No?
Your main prime accused has already been released. Prime accused has already been released. Prime accused, my lord, in this case.
Already released. Just wait for another date. We'll list it on Monday.
Sorry, Your Lordship, I was not there when the matter was called. Wait, please, Lordship, this is an anticipatory bail application. The FIR is at page 9. With due respect, I beg to inform you that yesterday on such and such at about so and so, my
What is the status of this person now?
My lord, he is back at home, my lord. He is back at home. And my lord, I was not the person against whom the allegation of attacking with the sharp weapon is there.
Where is the FIR?
FIR page 9, my lord.
Page 12 is the type copy.
Sorry, my
So
there is a.
You are Subrata Borgohain,
I'm
right?
Subrata Borgohain.
So the
allegation is against Aranya Borgohain, my younger brother. Thereafter, his youngest son, and in the middle, my lord, I'll read the entire one. I beg to inform you that yesterday on 21/5/26, at about so and so, my nephew Abhishek Borua, son of so and so,
Mr. Sharma, allegation is not against him. Page 16.
injury.
That I have seen.
My instructions are, my lord, the injuries were not serious at all. And it was during a football match. My lord, sorry, that was during a Bhavna. And this is a football match. He is fleeing.
We are granting him interim. Let's see. Heard Mr. P.D. Nair, the learned APP, learned senior counsel, assisted by Mr. So-and-so, the learned counsel for the accused applicant. Also heard Mr. B. Sharma, the learned APP for the state. Then the right decision application under section 482 of BNSS 2023, paying for granting pre-arrest bail to the accused applicant in connection with Nazira PS case number 25/2026 under section 118 in bracket 2/109 bracket 1/3 bracket 5 of the BNS 2023. Full stop. An FIR was lodged on 22/5/2026 at Nazira police station, alleging entirely a debt on 21/5/2026 at about 12:25 AM. A scuffle took place between his nephew Abhishek Borua and the applicant. And during that time, the younger brother of the applicant assaulted his nephew with sharp weapon. It was alleged that his nephew was injured, and thereafter he was taken to Shivsagar Civil Hospital initially, and thereafter to some medical college for treatment. Full stop. On the receipt of the FIR, police registered the Nazira PS case number 25/2026 under the aforementioned sections. Full stop. Also heard the submissions made by the learned counsel appearing for the respective parties. This court is of the considered opinion that at this stage, the accused applicant should be granted the privilege of interim pre-arrest bail. Accordingly, it is directed that the accused applicant shall be released on interim pre-arrest bail in the event of his arrest in connection with Nazira PS case number 25/2026 on furnishing of bail bond of rupees 30,000 with a security of like nature, subject to the following conditions. subject to the condition that the accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order and shall fully cooperate with the investigation. Full stop. Call for the next pair, call for the CD. Let the matter be fixed on 24th. 24th. Service.
So I think he is appearing. LCR has been already received, Lordship. TCR.
Or Mr. Chaudhary. Oh, you are appearing for this thing? Okay, I heard Mr. U. Chaudhary, Land Council appearing to the accused applicant. Also heard Mr. B. Sharma, and APP for the state, as well as Mr. D. Mehdi, the Learned Council appearing for respondent number 2. Respondent number 2. Mr. D. Mehdi submits that he has received the instructions to appear for respondent number 2. However, he is yet to file the wakalatnama. Therefore, he prays for some time to file the wakalatnama. Full stop. But let the matter be listed on next week, sometime in the next week.
Lordship.
Let the matter be listed on 21st.
21st. Obliged.
21st of July.
Can it be on 22nd, Lordship?
22nd? Okay, 22nd. 22nd.
22nd.
Charge sheet file. You go and approach there.
I'm barred for 81 days, my lord. I'm barred for 81 days. In the connected FIR, he has already been done to bail.
POCSO matter.
Also, my lord. There were 2 girls, my lord, who was arrested on 17th.
Okay, then you'll have to approach the trial court only. I heard Mr.
R.B. Goswami.
R.B. Goswami, the Learned Counsel, appearing for the accused applicant. Also heard Mr. B. Sharma, the Learned APP for the state. There is an application under section 43 of BNSS 2023, bring for granting bail to the accused applicant in connection with dispute PS case number 216/2026 under sections 87/74/75 in bracket 2 of BNS 2023, read with section 8 of POCSO Act 2012. Full stop. The Learned APP submits that a charge sheet in the instant case has already been filed by charge sheet number 381. Look 26. Full stop. In view of the aforesaid, the Learned Counsel appearing to the accused applicant submits that he should be given liberty to approach the appropriate forum for appropriate court for appropriate review. Full stop. In the instant bail application is accordingly disposed of with the liberty to the accused applicant to approach the jurisdictional court for appropriate relief. Did he not receive?
But I'm almost, lordship, 60 days, 66
Hmm?
days. Lordship, I'm in jail, lordship, 66 days, lordship.
90 days of this. Let the CD come. CD is not received. Let the matter be listed in the next week on next week. Next. 90 days offense. Monday will be difficult. I mean, we'll keep it on 22nd. Let the matter is on 22nd.
Obliged.
Yeah, please, lordship.
What is this additional affidavit all about?
4 persons, my lord, were arrested, my lord, by same forwarding, my lord. 2 persons have already been granted bail, my lord, by the learned session judge, my lord.
Hmm.
You know, that is why, my lord, I have and 2 persons here, my lord, in my petition. My lord. And if your lordship see the order, my lord, nothing, my lord,
CDS come.
my lord, no victims have been found, my lord.
No victims have been found.
Yes, my lord.
No victims have been found.
Not found, but as per the order, my lord, and as per FIR also, my lord, only on suspicion. Police personnel filed the
And who has filed it? FIR?
police, my lord. Whom? Tahidi Garam.
What is there in the CD? Hmm. But these two are main accused. In the FIR, who are there? So Mullah Zakir is the first person, and Martinul Haq. And Martinul Haq is also there.
My lord, kindly sit.
And who have been granted bail?
My lord, kindly turn to page.
Who have been granted bail?
My lord, Hassanur and my lord, Zahidul, my lord.
Where is the bail order?
My lord, bail order, my lord.
You have annexed?
Yes, ma'am. I have annexed. Page 38, my lord.
Page 38.
Yes, ma'am.
In the additional affidavit?
Yes, my lord. Yes. Page 38. I'd say I'm forwarding it. There is also violation, my lord, Article 20.
So, Mr. Sharma, now thing is that there may be some doubts. But
And my lord,
What specifically is the crime he has committed?
my lord, if your lordship, see my.
So
petition,
wait,
my lord.
wait, just I'm asking him, just let him reply, then you'll get opportunity. Please. Yes.
Trade license also.
How many days they are behind the bus?
My lord, 23 days, my lord, kindly, I want to show one thing, my lord, kindly. My lord, page 25, my lord. Page 25. Why, my lord, these things are found in my possession, my lord, kindly see, page 25. This is, my lord, a license, my lord, Mullah Zakir Hussain, Common Service Center, my lord. So this, my lord, Common Service Center is operating under the government of India, my lord, Digital India, my lord, where, my lord, in remote area, my lord, banking systems are not there, my lord, they can operate. This is the license, my lord. I have the trade license also, my lord. Kindly, I have annexed in my petition, kindly page 7, para 7, my lord. Trade license also I have, my lord. Para 7, page 7, my lord. I have stated, my lord. Because I am a license holder, I can operate the, my lord, minimum banking system in the remote area, my lord.
You are authorized to carry out banking service?
Small, my lord, some small transaction, my lord, because digital.
No, what
India-
kind of transaction?
My lord,
No,
market has
what
gone-
is banking service?
My lord, under.
What is banking service?
My lord, small, where my lord, my lord, money has to transfer, my lord, by. from you,
Is
my
this,
lord,
but transferring is banking service? Transferring is banking service?
my lord, like
Y-
this.
You see the definition of banking service. What
not
is the
like this,
definition of banking service? But no, maybe I mean, because it's a common facility center, I mean, the villagers go there and like they update their things. They do basically updation and all these things, right? Facility center. That you are writing here banking service. I mean, you should check your things, Mr. Advocate. Banking service is not, banking service is totally different. That billion, where is that, that you read? Some, the page 20, point number 4. Hmm. 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 Yes, what is this?
This, my lord, in bail order by the landed sessions, as my lord, this, my lord, order has been discussed, my lord, because there is also violation of 21, Article 21.
How?
Because, my lord, kindly, my lord.
What is Article 21?
My lord, right to liberty and personal liberty, my lord. Because, my lord, my lord, in kindly time to face, my lord, in our, my lord, bail application.
And how your personal liberty is curtailed?
Because, my lord, 2 times of, my lord, one, my lord, arrest time, and, my lord, taking, my lord, custody different time, my lord. That has been discussed. That is why, my lord, their bill has been, my lord, granted. My lord, para 43, my lord, of the additional immediate. Another judgment also has discussed, my lord. page 43 of the additional limit.
Heard Mr. S.S. Sikdar, the learned counsel appearing for the accused applicants. All applicants also heard Mr. B. Sharma, the learned APP for the state. This is an application under section 482 of BNSS. Sorry, 483 of BNSS 2023 for praying for granting bail to the accused persons in connection with Boko PS case number 175/2026 registered under sections 61 in bracket 2 bracket small a stroke 318 bracket 4 stroke 336 bracket 3 stroke 338 BNS read with section 66 bracket C. What is 66C and 66D?
My lord, 66, my
Sections,
lord.
read which
Identification
section,
of
eh?
theft, my lord. Identify theft, my lord. Identify theft. Up to 3 years. My lord.
Read with section 66C stroke section 66 in brackets, all capital D, capital D of BNS, of BNS.
66C and 61D available.
Facts of the case in brief are that on 19/6/2026, an FIR was lodged by SI Hirokjuti Mudoi at Boko PS stating therein that on 19/6/2026 at about 1:20 AM an information was received that one Mullah Zakir Hussain of village number 3, Dakhin Rangapani, PS Boko district Kamrup, along with his associates, have been involved in cyber-related fraudulent activities for a long time. Accordingly, a raid was conducted in his house and substantial incriminating materials were recovered from his possession. Full stop. It is seen that, next paragraph, it is seen that during preliminary inquiry, multiple Gmail accounts operating under the different names and identities were found in the mobile phone of the accused persons. The accused persons failed to provide satisfactory explanation regarding the ownership and purpose of those accounts. In addition to the aforesaid, several bank accounts, checkbooks, and other documents pertaining to different banks were also found from the possession of the accused persons. It was also alleged that the accused persons, by using an application in quotation in right, Gold Go, all capital Gold Go, have been transacting virtual coin transactions and USDT deposits, etc. It was also found that substantial balance, not alleged, it was also found that substantial balance was reflected in the name of the accused applicants. However, they could not provide any satisfactory explanation to the aforesaid source of funds. Full stop. Next paragraph, based on the aforesaid FIR, Boko PS case number 175/2026 under the aforementioned sections was registered by the police. Full stop. Next paragraph, you write. Next, learned counsel appearing for the accused applicant submits that the accused applicants were arrested by the police only on the basis of doubt, and police could not identify any victim in the victim of the alleged offense committed by the accused applicants till date. He further submits that the accused applicants have been arrested on 19/6/2026 and till date they are behind the bars. He further submits that the accused applicant number one is a common is operating a common service center for facilitating various financial transactions of the villagers, and accused number two is assisting him in his common service center. He submits that he submits that the accused applicant number one has the trade license and he has been operating legally the aforesaid common facility center. In view of the aforesaid, he submits that the accused, don't write in view. He further submits that a co-accused in the instant case has already been granted bail by the learned additional session judge Kamrup Amingam after perusal of the case diary. Full stop. In view of the aforesaid, he submits that the accused applicant should be granted bail at this stage. Full stop. Mr. B. Sharma, the learned APB, on the other hand, opposes the prayer for bail of the accused applicants. He submits that there are sufficient incriminating materials against the accused applicants regarding various cyber fraud committed by the accused applicants. Can you give me the case diary, please? Accused applicants and the accused applicants have been doing transactions beyond their resources. Full stop. He further submits that during the investigation, it was revealed that documents relating to current account maintained in the name of Milon Enterprise were recovered from the possession of the accused applicant. However, the accused applicant could not produce any business records, GST registration, trade license, and other supporting documents regarding the aforesaid Milon Enterprise. He submits that the documents of Milon Enterprise have been used by the accused applicants for possible unlawful financial transactions and concealment of criminal proceeds. And therefore, he submits that at this stage, since the investigation is still going on, the accused applicant should not be granted bail. This court has considered the submissions made by the learned counsel appearing for the accused applicants and have also perused the case diary that has been produced before this court. Taking into consideration of the fact that certain documents relating to various bank accounts in several banks, as well as amounts, as well as amounts in the accounts of the accused applicant, the sources of which could not be properly explained by the accused applicant, and the investigation in the matter is still going on. This court doesn't find any merit in the instant case, and therefore the instant bail application is rejected.
Lordship, may I kindly have a look at the last order, my lord, 25/6/26.
Yes, what is that?
Lordship, I found it, my lord.
Case diary has come. Yes or no, Mr. Doctor?
My submission, Lordship, may I kindly have a look at page 17, my lord.
Page number 17.
Page number 17, that is the
Allegation of killing
allegation of killing
of the daughter of the informant.
of the informant, my lord, that by another person, my lord. May I read, my lord? Brief of the case.
Page 17.
Page 17, Annex 2, my lord. May I read, my lord? Brief of the case, my lord. On 5/6/26, complainant so and so, my lord, lodged an FIR at this PS stating that on 3/6/26, around 3 PM, her daughter, Ms. Susmita Mandal, left the house, that's saying she was going to the market. However, she did not return home. By evening, they started searching for her. Through a reliable source, they learned that the accused, Vipul Malik, son of so and so, was seen by the villagers with her daughter in the market in the evening. Later on 4/6/26 and around 10 PM, they received news from the local people that a dead body was found in a paddy field at Gao Dimoria. They went to the spot and identified the body as that of her daughter, Susmita Mandal. Several stabbing marks of physical assault and injury were visible on her neck and stomach. The accused mentioned above trapped her daughter under false pretense, took her to secluded place and murdered her by stabbing by dagger. Although 10 months ago, the accused had developed a love affair with her daughter under false promise and made her pregnant. Consequently, a case was registered on so and so.
Yes.
Now, my lord, the next page, my lord, your lordship will see the name and address of the accused below, my lord. My lord, Anu Malik is the mother of the my lord, Malik, my lord. Number 2, my lord, is the brother-in-law, and number 3 is sister, my lord. So these 3 persons are before your lordship, my lord. Now, my lord, the allegation against them, my lord, your lordship will find, my lord. My lord, page 18, my lord, grounds of arrest, Roman 5, my lord. The accused person mentioned above are threatening the family members of the victim that they will release the prime accused on bail soon.
No, read from number 3.
Number 3, the accused person, that is Srimati Anu Malik, Srimati so and so and so and so, are mother, sister, and brother-in-law of the earlier arrested prime accused respectively, and they were closely associated.
What happened to the prime accused now?
Prime accused already got arrested, madam.
Got arrested, yes.
He is behind the bars, madam.
They are closely associated with the co-accused Vipul Malik.
My lord.
Bipul Malik is the main person
main person, my lord.
who has already been arrested. Then offense under investigation concerning the date of an 18-year-old girl is great.
Now, page 18, if I lordship, kindly see, my lord, the bold, my lord, below the, my lord, the grounds, my lord, a prayer has been submitted to the honorable court for adding 238 small a BNS 23 into the, in the instant case.
What is 238A?
238, my lord, destroying the, my lord,
Evidence.
evidence, my lord.
Hmm.
And why it has been inserted, my lord,
Hmm.
the lordship may kindly have a look, my lord.
Yes, why?
Why, my lord, then, lordship. My lord, the knife which was used by the, my lord, the main accused, my lord, he threw the same in the, my lord, the river. My lord, that remand order, my lord, it will reveal everything, my lord.
Which one you want me to refer to?
My lord, he had thrown away the knife, my lord.
Thrown away the knife in he showed that he has thrown away the knife.
Yes, my lord. So therefore, my lord, that evidence is no longer there, my lord. So therefore, my lord, this 238A has been added, my lord.
But 238A
Destroying of evidence.
destroying of the evidence by whom?
My lord, my submission is by the main accused, my lord, Bipul Malik, not by me. On the last occasion, my lord, the public prosecutor objected only to this point, my lord, as because 238 has been added, my lord, so bail should not be granted, so case diary may be called.
Yes, Mr. Boisho. No, what is the material showing that any involvement of these persons in the crime, in the crime?
Thirty-two days.
Hmm? Hmm. Hmm. He's already arrested. Now these three people are his relatives, mother or whatever. Now you tell me what is the material? Correct. So in the POCSO case, he got a bail. The POCSO case is still pending, right? The case is still pending, and he has got the bail, and he again came and like met with this girl and took her somewhere. Allegation is that took her somewhere, and like he supposedly killed him, and all the materials is forwarding report and like whatever. So that like he has stabbed her, and like after that like he has thrown the knife into a river. Correct. Now, those things are fine. Those things will be investigated. Now, only thing is that what are those materials showing or indicating or making any kind of doubt about the involvement of these other persons? So, is there any material on that? That is what I need to consider. I don't think anything else is to be considered. How? How? No, those. Okay, we'll come back. We'll come back. We'll come back, Mr. Doctor. 5 minutes. Just give time. Yes. On a POXO case involving this same girl. Same girl.
In the instant case, POXO is not there. And the only allegation, my lord, which has been leveled against the present petitioner, my lord, that your lordship will find at page 18, my lord, Roman 5.
Page 18.
Page 18, Roman 5. Five and 6. "32 days behind the bars. And they had a child, she had a child, my lord. I had made a specific statement, my lord, in paragraph 5, page 7. My lord. Sorry, page 5, paragraph 7.
Now how many days?
32 days.
32 days. Let them go. I mean, nothing is. The only ground you're citing is that the prosecution is citing is that, I mean, they may intimidate or this thing. Right? Or influencing there is no involvement, prima facie, nothing is there. Right, heard Mr. N.J. Datta, the learned counsel appearing for the accused applicants. Also heard Mr. K. Busha, the learned APP for the state. This is an application under section 483 of BNSS 2023. Paying for bail of the accused applicants in connection with Khatri PS case number 43/2026 under section 103 in bracket 1 of the BNS 2023 added section 238 in bracket small a of BNS 2023. The brief facts of the case that on 5/6/2026, complainant, right, informant Sri Asapurna Mandal lodged an FIR before Khatri police station, alleging that on 3/6/2026 at around 3 p.m., her daughter, namely X, left the house saying that she was going to the market. However, since she did not return home by the evening, the family members started searching for her. It was alleged that through reliable sources, they learned that accused Bipul Malik was seen by the villagers with her daughter in the market area in the evening. Full stop. It was alleged that on 4/6/2026 at around 10 p.m., the family members received news from local people that a dead body was found in the paddy field at Gauhati. On receipt of the information, they went to the spot and identified the dead body to be the daughter of the informant, and they found several stabbing marks of physical assault and injury on the neck and stomach of the victim girl. It was alleged that the accused trapped the daughter of the informant under false promises and took her to a secluded place and thereafter murdered her. It was also alleged that about 10 months ago, the accused developed a love affair with the victim girl under false promises and made her pregnant, and consequently, a case was registered at Khetri Police Station. That is case number 60/2026 under section 64 in bracket 2 bracket small m of BNS 2023 read with section 16(6) of POCSO Act. It was alleged that the accused was sent to judicial custody, but after being released on bail, the accused harbored deep resentment and accordingly planned his offense of committing murder of the daughter of the accused, the daughter of the informant out of revenge. Full stop. On receipt of the FIR, the police registered the Khetri PS case number 43/2026 under the aforementioned sections. Full stop. Mr. N.G. Doctor, the learned counsel appearing for the accused applicants submit that the accused applicant number 1 is the wife of accused applicant number 1 is Namita Rajbangshi is who?
Sister.
Is the sister of the main accused, that is Bipul Malik, and accused applicant number 2, namely Mridul Rajbangshi, is the brother-in-law of the accused applicant and of the main accused, and accused number 3 is the mother of the accused of the main accused. He submits that the accused applicants are no way linked to the alleged commission of offense by the main accused, namely Bipul Malik. He submits that only due to suspicion and being the family members of the accused person, they have been arrested by the police for no fault of theirs. He submits that the accused applicants were arrested on 12/6/2026, and for the last 32 days, the accused applicants are behind the bars. He further submits that accused applicant number 1 is a mother of 4.5-year-old child, and presently the child is in the custody of his grandfather, and due to the aforesaid fact, the accused applicant as well as the family members, including the accused applicant number 2 and 3, are going through a lot of problems. He submits that the accused applicants are responsible citizens and going to, and going to cooperate, fully cooperate with the investigation in the instant case. Full stop. Therefore, he prays for granting bail to the accused applicants. Full stop. Mr. K. Basha, on the other hand, submits that the main accused, namely Bipul Malik, was involved in a POCSO case earlier involving the victim girl, and after his release, he had committed the murder of the victim girl out of revenge. He submits that the accused applicants are family members, are also involved in shielding, shielding the accused, the main accused in the instant case. And there are a lot of possibilities that in the event of their release, they may try to influence the witnesses involved in the instant case. Therefore, he opposes the bail application. Full stop. This court has heard the submissions made by the counsel appearing for the respective parties, as well as peruse the case diary that has been produced before this court. Before this court. Taking into account the entire facts of the case, as well as the possible and prima facie involvement of involvement of the accused applicants in the commission and in any way supporting the accused applicant, is of the considered opinion that at this stage the accused applicants should be granted bail. Accordingly, it is directed that the accused applicants shall be released forthwith from jail on furnishing of bail bond of rupees 30,000 each with a security of like nature to the satisfaction of
CGM's Kamrup Metro.
CGM Kamrup Metro, subject to the following conditions. Number one, the accused applicants shall fully cooperate with the investigation and make themselves available as and when called for by the investigating officer. Number two, accused applicant shall not try to influence or intimidate any of the witnesses that may be involved in the instant case. Full stop. Next para. The prosecution, the investigating officer. So no, don't write anything. Then you write, in terms of the aforesaid direction, the instant bail application is disposed of. CD to be returned.
I'm obliged.
You can keep
Yes,
this.
ma'am. I'm obliged.
CD was called for, madam. FIR is at page 12, my lord.
What is the FIR? What is the allegation?
Allegation, my lord, I misrepresented some amount, my lord. It's
Huh?
at page 12, my lord.
Page 12.
Yes, my lord. Can you see? With due respect, I would like to submit that Nikhil Sharma, that's me, my lord. Ram Sarup Sharma, second plot Goddes Gali, Barshapara, Binagar, Assam, pin so and contact number so and so, who introduced as a CA. I'm not a CA, my lord. I work with my lord, CA, my lord. And looking after my PF, ASIC and GST files, recently GST department gave me notice dated 21/2026 regarding summon under section 70 of the GST Act 2017 for zero cash tax payment despite substantial turnover. The above said person was filing my GST on behalf of me due to
How much? 2 crore 44 lakhs.
Yes, my lord. Can you see, my lord, that is in the last part, my lord, say March, my lord, March 2021, my lord. I'm dealing with him. Can you see? Dated March 13, stated that payment for March 2021 was received 5100. Now, my lord, June 2026, my lord.
1 second.
After 5 years, my lord.
Just a minute, Mr. Raman.
Can you see, my lord?
Yes.
The matter released to my lord March 2021. And now my lord, he lost a complaint, my lord, against me that I did not deposit money.
No, that is right, but like he has been paying the amount to you to deposit the GST, but you are not paying.
Correct, my lord, correct.
And you are not paying, therefore he received the notice.
My lord,
And
then, my
he
lord,
got to know only when
then
he
my lord,
received.
notice would have gone on in the year my lord, 2022, my lord. March 2022, my lord.
No, that investigation will reveal what has happened
And
exactly.
my lord, I'm in custody for my lord last 18 days, my lord.
But a huge amount of fraud. So what is there in the CD? See, he is not a CA. Some fake document by saying that like he has paid it. Sir Rahman, you'll have to spend some time there, eat some rice there, rice and dal.
It's a trial, my lord, is a forgery, my lord. I'm saying,
No, I understand, but
Right stage, my lord, if I am found
that
guilty, my lord, if I am found guilty, my lord.
materials and your
Can you see
conduct,
the affair at my lord?
conduct is not very,
Can you see, my lord, March
conduct is not
21?
very forthcoming,
You
Mr.
could have, my lord,
Mr.
was a
Rahman.
complaint in the year 2022 or
Conduct is
2023,
not
my
very
lord.
forthcoming.
Can you see, my lord?
You'll have to spend some more time. Heard Mr. S.S. Rahman, SSS Rahman, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, the learned APP for the state. There is an application under, you write this, application under so and so, so and so. Then you write. An FIR was lodged by one Janardhan Deka on 1/6/2026 before the Boko police station, alleging that the accused applicant representing himself to be a CA got introduced to him, and after gaining his confidence, the informant started giving him work for service of his PF, ESIC and GST file. Accordingly, according to the informant, informant as directed by the accused applicant, kept on submitting various amounts for depositing the same before the tax department. Full stop. It was alleged that the amount as on 26 as on the amount that has been deposited, by the informant comes to around rupees 2 crores 44 lakhs 12 lakhs 247, excluding certain other amounts. Full stop. The accused applicant and the informant was under the belief that that since he has been paying those amounts to the accused applicant for depositing the same before the GST authority and tax departments. Before the GST authority, the same has been deposited by the accused applicant. However, on 21/2026, the informant received a notice from the GST authority. GST authority summoning the informant and alleging zero cash tax payment despite substantial turnover. The accused after coming to know about the aforesaid, the accused, the informant has filed the FIR. Filed the FIR, full stop. On receipt of the FIR, the police registered Boko PS case number 143/2026 under the aforementioned sections. The case diary in the instant case has been received and the same is perused. This court has also heard the learned counsel appearing for the accused applicants. On perusal of the case diary and after having found sufficient prima facie incriminating materials against the accused applicants, this court is not inclined to grant bail to the accused applicant at this stage. Accordingly, the instant bail application is rejected. No other way at this stage.
47. That case diary was called for lawsuit, and petitioner is on interim.
Did not receive. CD is yet to be received. Let the matter be listed on 22nd. Interim order so passed by shall continue to the next date of list. 24th. Mr. Rahman, 24th.
That is all. 48 is the anticipatory bail, my lord. 40, I'm appealing for 48, my lord. 48 is the anticipatory bail, my lord. Here, my lord, you kindly have a look at the FIR, my page 8, my lord. Page 8 is the FIR, my lord.
Yes.
My lord, here, my lord, I have not seen the FIR, my lord, here. Firstly, one Habibu, my lord, not just seen the FIR. Habibu was the person who called the informant, my lord.
Hmm.
Informant happens to be one Sofikul Islam, my lord.
Hmm.
Now thereafter.
Money was paid to whom? Amir.
No, in presence of Amir, my lord.
In presence
It
of
is
Amir.
before lordship, my lord. He has no grievance against me, my lord. So far the FIR goes, my lord. Because kindly see, my lord, there was Habibu.
The FIR, the Mahabharata will not be written in the FIR,
He's
Mr. Chaudhary.
Definitely, my lord. Here.
What is there in the CD?
Can I just two aspects?
Hmm?
Let him say.
Is there anything else you want to say? I have read the FIR.
Here,
Got
my
to
lord,
know.
what I mean to say, my lord, here, if your lordship kindly see page 10, my lord, there are 3 persons are named in the FIR, my lord, by the informant. And informant has lost this case after how many days, my lord? Kindly see, my lord, the last line of the, my lord, FIR, page 9, my lord.
The incident took place in 1512.
Yes, 15/12/2025. And the present FIR has been lost on 23rd April, first page, lordship find, page 8, my lord, 23rd April 2026. So after 4 months, 8 days, this was lost. And after so much of deliberation, he has lost this case. And so far the FIR goes, he has no grievance against me. Only thing, my lord, he states that, my lord, that last line, my lord, last 8 line, out of fear of my life and the safety of my family, on the following day, in presence of Amir Mondal, I paid the said amount. So in my presence, he is known to me, my lord. My lord, he is also having some business. We are known to each other.
You are friends.
Was acquaintances, friends, my lord.
You are friends.
Possibly, my lord. Yes, yes. Not the best of friends, but they are known to each other.
Okay.
So, only thing, my lord.
So you call Amir Khan to help you out, that you be a witness of payment. And how come Amir Khan, this person went there?
The affair does not reflect, my lord, how and why.
What is your instruction?
Our instruction, yes, that he called me, what should I do? So, as per the affair also. So, my lord,
No, you tell me, FIR I have read. Now you tell me how this accused applicant.
Yes, my lord.
Amir Hussain Mondal.
Yes, my lord.
Was present there.
As per the instruction of the informant, my lord, he went there, my lord, because he was not there. So informant asked him, my lord, and he. So it says on the next day, my lord. So on that time, at the time when the whole thing, my lord, whole incident occurred, my lord, he was possibly not there. The present petitioner, my lord.
Maybe it doesn't reflect from this.
Yes, on the next day, kindly see, my lord, out of fear that around 10th line for page 9, my lord, from below, my lord, out of fear of my life and the safety of my family on the following day. So on the next day, my lord. So
your case, the next day you call Amir Mondal.
Yes. And my lord, another aspect, kindly see, my
lord. So why are you fearing arrest then?
He himself is in fear of these people, my lord. The informant himself is in fear of these people, my lord. Kindly see, my lord.
No. What is your apprehension then? If he is your friend, he has only called you to be there while paying the amount as a witness. What is your fear of? What is your apprehension?
Because some other persons who are not named, my lord, they have been apprehended, my lord.
No, that is different thing. But what is your this? I am a friend of his, the informant. You are the friend of an informant.
Yes, man.
Then informant has told you. Then what is your fear?
My name appears, my lord, in the affair, my lord. My name appears in the affair, my lord.
So your name appears in the affair, then how can you say two things at the same time? That you are a friend, you have been called.
No, my lord. So I couldn't place it, my lord. The affair states my name not as an accused, my lord, but there is a reference of my name in the affair.
Correct. That's what I'm saying. You are not an accused. So you are a friend of his. So what is your fear? That's what I'm asking.
My lord, here, my lord, kindly see Anisur also named, my lord. But there
Anisur, Habibur, and Ayub Ali Sheikh named.
Yes, my
You are not named. Your references come only as a. You are saying that you are saying that he is a friend of yours, and you are there. What is your apprehension then? What is your apprehension?
Police is after me, my lord. They have visited my residence, my lord.
Where have you stated so?
Yes, well, para 3, my lord. Phase 4, my lord. Phase 4, para 3, my lord. And kindly see, my lord, after 4 months, he has lost this FIR, my lord. And he himself was under fear and
because he was ashamed. He has been honey trapped.
Yes, that is, my lord.
So he was ashamed.
Yes, yes.
He doesn't come out, say that I have been honey trapped.
But if there was any overact, my lord, or
Hmm.
illegal act by the present petitioner, my lord,
Okay, I heard you.
would have
What
definitely
what is
stated in
that,
the FIR, my lord.
Sharma? One is Habibur Rahman, he's one of the accused. And other one is supposed to be, only supposed to be there, his presence. Any reference? Is there any material? Hmm. Last? 61 days. Huh? Huh? Oh, he's already 61 days. Okay. So he's the default bail. Hmm. Hmm. What informant? And like this person is always there in all these cases also. Difficult, Mr. Chaudhary.
Let him finish.
So he made some money out of that. Money. He tells that like, I'm a friend of yours and parity, no parity.
But those. Yeah, my lord, kindly see, my lord.
Okay, you right.
But these are I'd leave it to a lordship discretion. These are statements of co-accused, my lord, who were arrested, and those statements possibly made before the
Okay,
investigation. officer.
investigation will reveal that. Investigation will reveal that, but
before
at
the-
least at this stage, there are certain prima facie material against you, and the investigation has to be completed.
Definitely, my lord, the case will hinge upon the informants, my lord, his witness, my lord, his statement, my lord. Oh, whether
Correct,
it
correct, correct. Okay, I got it.
I leave it to
Your name heard, Mr. Huh? A.N. Iqbal, the learned counsel. This is the bail application number 1395, not the one or we had 1395. Huh? Heard Mr. So and so. I also heard Mr. B. Sharma, the learned APP for the state. Then you write this is an application. Then you write. You write, the prosecution case is, in brief, is that on 23/4/2026, the informant, namely Safiqul Islam, who has a pharmacy at Basugaon, lost an FIR alleging that on 15/12/2025, one of the accused, one of, 1 second, on one of the accused persons, namely the FIR, called the informant to his house to discuss for a treatment of a patient. When next full stop, when he reached the accused applicant's house, alleging that on 15/12/2025, the accused applicant called the informant to his house to discuss for treatment of a patient. Full stop. When he reached the accused applicant's house at around 9:30 p.m. after closing his pharmacy, the accused applicant showed him an unknown woman present at his house and told him that she required some treatment, and thereafter left the room. After his leaving, some persons knocked on the door of the house, and the woman who had already closed the door opened the door. On opening of the door, three persons entered the room and started threatening and beating the informant, and asked and forced him to sit with the woman and demanded money from him, demanding him to confess his involvement in immoral activities with her and immoral activities with her. Full stop. The three accused the three unknown persons claimed themselves to be NDF members and threatened to kill him and his family. On the next day, the accused applicant had to pay over rupees 2,30,000 in cash to the accused applicant in the presence of one persons, namely Amir Hussain Mandal. On the receipt of the FIR, the police registered Basugam police station case number under the aforementioned sections. After the investigation, then you write the police arrested. Next para, the police arrested the accused applicant on 13/5/2026, and since then he is behind the bars. The learned APP submits that the petitioner, that the accused applicant is already behind the bars for last 61 days, and since he is accused of offenses under section 308 in bracket 5 stroke 127 bracket 2 stroke 61 bracket 2 of BNS. He is eligible for default bail at this stage, since he has already spent a mandatory 60 days behind the bars. Taking into account the aforesaid submission, it is direct that the accused applicant shall be released forthwith on bail on furnishing of a bail bond of rupees 50,000 with a surety of like nature to the satisfaction of which court? CGM, Sirang, Kajalgaon. Kajalgaon, subject to the following conditions. Number 1, the accused applicant shall fully cooperate with the investigation, and he shall make himself available as and when called for by the investigating officer. The accused applicant shall not number 2, in terms of the aforesaid directions, the instant bail application is disposed of. Then AB, you write. Heard Mr. A. Chaudhary, the learned counsel, preparing for the accused applicant. Also heard Mr. B. Sharma, the learned APV for the state. Then you write this is an application. Then facts you write that FIR, the FIR thing you write there. Then you write the learned counsel preparing for the accused applicant submits that the accused applicant in the instant case is not named in the FIR as an accused. However, his name was mentioned as a person who was present while the LA's money was delivered to the accused persons by the informant. He submits that since his name has been mentioned in the FIR, and his name has come in the FIR, has come in the FIR, though not an accused, though not as an accused, the police is searching for him, and the police has visited his residence several times. He submits that in view of the aforesaid, he has serious apprehension that he may be arrested in connection with the instant case, and therefore prays for prays for prays for prays for his release on pre-arrest bail. Prays for pre-arrest bail, not release. Prays for pre-arrest bail. CD in the instant case has been received, and the same is perused. The learned APP submits that there are sufficient incriminating materials about the involvement of the accused applicant in the instant case. He further submits that sufficient materials have been gathered by the investigating officer regarding the involvement of the accused applicant in some other cases wherein also similar modus operandi has been adopted by the accused applicant to extract money from innocent victims. Therefore, he prays for rejection of the bail, rejection of the bail at this stage. Full stop. This court has heard the submissions made by the counsel appearing for the respective parties, as well as has gone through the case diary. On perusal of the case diary and having found sufficient prima facie materials against the accused applicant, this court is not inclined to grant any relief to the accused applicant at this stage. Accordingly, the instant AB application is rejected at this stage.
Kindly see the FIR. FIR is at page 7.
Respondent number 2 has been served.
Yes, she appeared.
You have filed objection.
Already is there.
What is your objection? Who are you?
My lord, page 7. The FIR lordship. In fact, lordship, there was the lab affairs. In fact, no such relation of physical was taken place, lordship. Only
CD has come.
lordship, my instruction is that no physical relation was taken place. In fact, there was a love affair. She voluntarily left her own residence and came to.
How old are you?
My lord, I am lordship 30 years.
Huh?
I am 30 years.
30 years, you take a girl in love affairs and keep her in your house without informing the parents. What kind of love is this? Do you really love her? Will you do that kind of thing if you fall in love with somebody? Then at least you will intimate the family members that I have taken her, I'm in love with her, something you'll say, no? But without telling the family members, you have kept her there and you say that you are in love with her. This is not believable. No?
She came to the residence and after that lordship, she was handed over to.
Okay, heard Mr. M.A. Khan.
M. Khan.
Sorry, M. Khan, the learned counsel appearing for the accused applicant, also heard Mr. B. Goswami, the learned APP for the learned APP for the state. When you write decision application under section 482 of BNSS, paying for you write this, huh? Paying for this. An FIR was lodged on 742026 by one Sipra Mandal, the informant, alleging that on 26/3/2026 at about 8 p.m. her minor daughter was missing from her residence. And later on, it was found that the accused applicant took his minor daughter with the promise of love and wrongfully confined her in an unknown place. Due to the aforesaid act, the informant's daughter became mentally ill. Full stop. On receipt of the FIR, police registered the Bongaigaon PS case number 51/2026 under the aforementioned sections. The learned counsel appearing for the accused applicant submits that there was no such offense has been committed by the accused applicant, and due to love and affection, the victim girl went with him voluntarily. Full stop. The Mr. B. Goswami, the learned APP. What's your name? The write her name also, third R. Saha, the learned counsel for the respondent number 2. Then the right, Mr. B. Goswami submits that there are sufficient incriminating materials against the accused applicant of his involvement in the incident, of his involvement as alleged in the FIR. Therefore, he opposes the bail application. MS Saha also supports the submission made by the learned APP and opposes the bail application. Full stop. This court has heard the submissions made by the counsel appearing for the respective parties and has also perused the case diary. After finding prima facie sufficient incriminating materials against the accused applicant of his involvement in the offense as alleged in the FIR, this court is not inclined to grant any relief to the accused applicant at this stage. Accordingly, the instant AV application is rejected.
My lord, item 54, my lord. I apologize, my lord. In the morning hours, it slipped out of my mind, my lord. Item 54, I filed an additional affidavit, my lord. I may be allowed to bring it on record.
It will be difficult now.
I have already filed, my lord.
Okay, let him know.
Allow.
Left on here. You go there.
Scan copy.
Why? You go there. Hmm? Charges submitted, you go there and apply.
Observation,
Huh?
an observation.
Observation means like you go about where the liberty is already there. Heard Mr. M. Ali, the learned counsel appearing for the accused applicant, also heard Mr. P. Botakur, the learned APB for the state. And this is an application under so and so, right? Huh? Then you write the learned counsel. Then you write brief facts of the case are that on 10/11/2025, Deputy Superintendent of Police D. Mahasau lodged an FIR before officer in charge Rangajau Police Station, alleging inter alia that based on secret information on 10/1/2026 at about 8:45 p.m., one Tata six-wheeler truck bearing registration number A01QC, this 8857 was intercepted at Ditok Chera, DITTOKCERRA, check gate, Boro Narayanpur, 27 National Highway, coming from Borkhola, Silsar side to Harangajao, and apprehended the driver, namely Muhammad Nazrul Hussain. After searching the vehicle, he recovered total 50 numbers of plastic boxes containing total 576.72 grams of suspected brown sugar heroin from the vehicle, along with cash of rupees 3100 and 2 numbers of mobile handset. The petitioner was later on arrested, and this copy of vehicle, copy of vehicle bearing number A01-FZ-3257 and 2 mobiles handsets were seized by the police. On receipt of the FIR, on receipt of the FIR, police registered Harangajau Police Station case number 1/2026 under section 21 in bracket capital C /21 bracket 1 of NDPS Act. The learned APP submits that charge sheet in the instant case has already been filed by charge sheet number 10/26. The learned counsel appearing for the accused applicant submits that he should be given liberty to approach the appropriate jurisdiction court for appropriate relief. In view of the aforesaid, this instant bail application is disposed of with liberty to the accused applicant to approach the jurisdictional court for appropriate relief.
Please, Your Lordship. Pre-arrest bail application, Lordship. Lordship will find the FIR on page 9, Lordship. The section which has been implicated here is section 65, section 87, and section 6 of POCSO Act, Lordship. Lordship has found the FIR, Lordship, on page 9, type copy, Lordship.
The girl has been recovered.
Yes, Lordship, I have annexed the order which has, her statement has also been recorded, page 19, Lordship. And as per my instruction, Lordship, victim has left home on her own accord, Lordship, and there is closeness of age also, Lordship. The girl is 16 and the petitioner is 20, Lordship. Genuine adolescent relationship, Lordship. And The FIR was lodged on 28.
16 years old girl. So, I mean, whether it's a love relationship, whether it's a consent, whether it's non-consent, doesn't matter.
Lordship, on the date.
I mean, statute is like that, right? Below 18, if you have any kind of sexual intercourse, then you are liable. So, I mean, here, whether there is a consent, there is no consent, doesn't matter. That is the thing.
Uh,
What is her statement? The case is, I mean, already charged sheet matter.
Yes, sir. No,
Huh?
no, no, not charged sheet, not charged sheet.
Why this TCR has come?
I am not aware. Earlier occasion, the CD came, but the CD was kept in the PP sort.
TCR was called for. How come TCR has come? It is below 16 years.
As per FIR, it is 16.
No, as per birth certificate also.
Sir, relying on a Supreme Court observation, Lordship, in such cases, Lordship, may I refer?
Then POXO has to be taken out. The provisions of POXO has to be taken out then. If somebody is, 15 years old and somebody does some kind of physical thing with her and she gets pregnant, then if you say that like there is a voluntary this thing, then POXO has to be taken away. What Supreme Court has said?
In this
Man,
case,
that
the
case
reporting
definitely has to be misplaced or like you have misread the case.
the observation which has been made at
Hmm.
last. where
Yeah,
Supreme-
what observation? You did?
Lordship, here Supreme Court has, Lordship, by observing various.
What was the age of the girl?
Lordship,
What was the age of the girl there?
Lordship, in this case, Lordship, age of the girl was 16, Lordship.
Then?
And thereafter, by observing various observation made by various high courts, Lordship, the Supreme Court has observed that the government of India must consider initiation of steps by possibly curbing the menace inter alia to introduce a Romeo-Juliet clause exempting genuine adolescent relationship.
Has it been done by Government of India?
It has not been done, but the facts which has been considered in the case, in this case, and the other high court cases observed.
Bail has been granted.
Yes, Lordship, in that cases, in Supreme Court's order, Lordship, the one case with Delhi High Court in Sahil versus.
No, the Supreme Court has granted bail.
In this case, Lordship, the appeal was considered, Lordship. The bail is granted, Lordship. Bail granted in terms of this judgment and order is
It was an appeal.
appeal, Lordship.
The appeal is a different thing.
My submission is. this
There was a
20 years.
appeal means there was a conviction there.
Lordship, appeal in terms of for determining whether High Court, in this case, the point of determination was that whether High Court at 439 application, can High Court initiate a mini trial?
Mini trial is a different thing.
Later on, these observations were
Mini
brought.
trial is a different thing.
Later on, these observations were made.
That will
And
not be applicable
In
here.
my case also, Lordship, the petitioner is 20 years of age, Lordship. And
So I mean, now if you say that like we need to change the ages, majority and minority, you are a major and you have committed something with a minor. It is as simple as that. The Romeo Juliet clause and all these things, those are fine. Those are fine. Those things are required to be taken into account. But like when the statute is there, we can't do anything on this.
This, as per my submission, this is genuine romantic adolescent relationship, Lordship, and putting him behind the bar.
Can we bypass the POXO
No,
Act?
it cannot be. As of now, it cannot be.
We cannot. I mean, if government takes some legislature comes with some kind of exemptions, taking into account the facts of the particular facts of the case in a, I mean, then it's a different thing. I understand like the girl has gone voluntarily, but thing is that she's a minor. She doesn't understand the repercussions. She doesn't understand the consequences of her act. That is why POXO has been brought in. There may be lot many things.
May I submit one more thing, Lordship? The FIR was lodged on 28/5. Thereafter, when the petitioner came to know, he voluntarily went with the victim to the police station. Whether his statement is recorded, that may be seen in the
What
case.
statement?
Because the petitioner voluntarily went to
No,
the
no,
police
that
station.
is there that they have gone voluntarily.
Yes.
But whether that will, I mean, evade your commission of offense as per
Custodial
the
interrogation might not be required, Lordship, as my statement is recorded already, Lordship.
your statement is not recorded.
As I have voluntarily went to the police station and they have thereafter on 30, that is 30.
See, POXO case, I mean, it cannot be, I mean,
30 of May, the FIR was registered.
difficult.
Custodial interrogation might not be required, Lordship, as considering the statement of the victim, considering the age of the petitioner, Lordship. That might be considered, Lordship.
No, this is fine. I mean, he is arguing that like, he is arguing that as part of statement also, the girl has gone voluntarily. And both of them surrendered or whatever before the outpost. Now, statement has been recorded of the girl. Now, whether custodial detention is required or not. That is he saying. She said that like she has voluntarily, she participated voluntarily. No, that is correct. I mean, as far as this thing is, but whether further custodial detention is required for this boy. No, it's not up to this, what is your submission on that?
Influence at this stage, Lordship, because victim's statement has already been recorded and she herself states that she voluntarily, the inducement and influence might not come in this case, Lordship, regarding the victim, Lordship.
Correct, pregnancy is there.
Just offenses committed with the age of the petitioner, Lordship. There is every chance of reformation, Lordship, at this age, Lordship. 20 years of age, Lordship. Putting him behind the bar will affect drastically, Lordship.
Let him go. Your objection will be there. Okay, heard Mr. D. Medhi, the learned counsel appealing for the accused applicant. Also heard Mr. B. Goswami, the learned AP. Huh? Vidut Sharma. Oh, he is also from here, so I thought you had this one. B. Sharma, the learned APP for the state, as well as M.K. Brown, MS M.K. Brown, the learned amicus curiae. Amicus, right? Learned amicus curiae for the respondent number 2. Full stop. This is an application under section 482 of BNSS 2023. Praying for granting prioress bail to the accused applicant in connection with Laluk PS case number 103/2026 under section 65 in bracket 1/87 of BNS read with section 6 of POCSO Act. Full stop. The case relates to an FIR dated 28/5/2026 lodged by the informant alleging that her daughter MSX, aged about 16 years, went out for college on 26/5/2026, but she did not return home. On being searched, they came to know through a telephone that she was staying with the accused applicant of Santipur of Dhemaji district. On their return, after medical examination, it was found out that the daughter of the informant was pregnant of 1.5 months. On receipt of the FIR, police registered the Laluk PS case number 103/2026 under the aforementioned sections. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicant and the victim girl, accused applicant who is 20 years of old, is in love with the victim girl and the victim girl, full stop. Victim girl and the accused applicant went to Arunachal Pradesh voluntarily and stayed there for 2 days, and thereafter, when they came to know from the family of the victim girl that a case has been filed, they voluntarily surrendered, voluntarily appeared in
Laluk, yes.
appeared before Dulhat outpost. Dulhal outpost. Full stop. He submits that after their appearance, the statement of the victim girl has already been recorded by the police. 183 statement.
183.
Under 183 of BNSS, and therefore further custodial detention of the accused applicant at this stage may not be required. He submits that accused applicant is also a young person of 20 years of age without having any past criminal antecedent. He submits that in the event of his arrest by the police in the instant case, is he studying?
Lordship, as per my instruction, he has left studies. Lordship.
Hmm?
He has left studies.
His left study. His life will be in jeopardy, being a young person of 12 years or 20 years also. He submits that he will fully cooperate with the investigation and he shall not temper or try to influence any evidence in the instant case. He further submits that since the victim girl has voluntarily gone with him, though a minor, and since he is willing to cooperate with the investigation, he should be allowed to go on pre-arrest bail. On the other hand, the learned APP opposes the bail to the accused applicant, saying that the girl being a minor, without having any knowledge of the consequences, and therefore consequences, and the investigation in the matter is still going on. Therefore, at this stage, the bail to the accused applicant should not be granted. Ms. M.K. Brown, the learned amicus curiae, submits what will be your submission? Submits that in the event of release of the accused applicant, he may influence the girl and thereby hampering the investigation. Therefore, she opposes the bail to the accused applicant. Next, case that in the instant case has been received and the same is perused. It is seen from the records that the victim girl has voluntarily eloped with the accused applicant and stayed with him, and she had stayed with him. Full stop. Her statement under section 183 of BNSS has already been recorded. It is seen from the records that both the accused applicant and the victim had voluntarily came back and surrendered before the, before the Dulhat outpost. Taking into account account of the fact that the statement, take account of the fact that fact that both the victim girl as well as the victim girl as well as the accused applicant are young persons, young persons, and investigation in the instant case one second. Taking into account of the fact that the investigation in the matter is almost complete. Almost complete. This court is of the considered opinion that further that custodial detention, the accused applicant may not be required in the instant case. Accordingly, it is directed that in the event of arrest of the accused applicant, he shall be released on furnishing of a bail bond of rupees 30,000 with a surety of like nature, subject to the satisfaction of the arresting authority, subject to the following conditions. The accused applicant shall appear before the investigating officer within a period of 10 days from the passing of the, 10 days from passing of this order, then the accused applicant shall not try to get in touch with the victim girl and shall not try to influence any witnesses, that may be connected with the instant case. Number three, the accused applicant shall fully cooperate with the investigation, and whenever he is whenever he is called for, he shall appear before the investigating official. Just next paragraph. In terms of the aforesaid direction, the instant AV application is disposed of as allowed.
Deeply obliged, Lordship.
Appeal also. Also, this is a free arrest bail application also. The FIR is at place 15 also.
FIR is at okay, CD, heard Mr. S.K. Das, the learned counsel, appearing for the accused applicant. Also heard Mr. B. Sharma, the learned ABE for the state. CD is yet to be received. Let the matter be listed on 22nd. 22nd. Huh?
It's a short date, huh?
22nd.
22nd. Problem.
Maybe.
You have filed? Yes.
Yes.
Okay.
Call it receipt, Lord. Right, okay.
It has come, it has come.
Receipt. Yes, right, receipt. Yes. Lordship, here in this case, Lordship, after case 9, Lordship, 11 page is 13. Lordship, here victim is 18 years, Lordship. And Lordship,
Service is complete, he is appearing.
Lordship, affair is registered, Lordship, on refusal to marry, Lordship, under section 69 of BNS, Lordship. And Lordship, in this affair, it is categorically mentions, Lordship, it is consensual relations, consensual relationships, Lordship. And Lordship.
Okay, let us see what is there in the.
Lordship, one more thing, Lordship. In affair, Lordship, it is mentioned she is pregnant, Lordship. Lordship, now Lordship kindly come into Lordship, medical.
One second.
The last line, Lordship.
One second. Just give me 2 minutes.
Lordship.
Yes.
Lordship. Lordship, in this affair, Lordship, it is categorically mentions that there is a relationship. And Lordship, she was pregnant. And Lordship, now Lordship, she, peasant petitioner was promised to marry. Lordship, that's why Lordship, the relationship and become pregnant. And Lordship, now Lordship, kindly come into Caesar list. As per the Caesar list, Lordship, the victim, she herself lost this affair. And as per this Caesar list.
No, whether the ingredients of 69 is complete or not, complied or not,
Lordship,
is there or not?
Lordship, that's why.
69 is there.
Lordship, so far my understanding, Lordship, Lordship, mayor refusal to marry is not an offense.
Deceitful
Yes,
way.
Lordship.
He has been saying that he will marry him,
Lordship,
marry her.
Lordship, that's why I am saying in her statement, Lordship, it is mentioned the peasant's petitioner's parents was not accepted.
That is a different thing. That is a different thing. That is a different thing. I mean, only parents did not agree, then you will not agree.
No, Lordship. I'm not, Lordship. So far.
See, who is the person, parents or you? You are marrying or parents are marrying?
Lordship, I'm saying.
No. I'm asking you whether you will marry or your parents will marry.
Lordship,
you will marry.
Yeah, Lordship.
The whatever things have been done by you.
Yeah, Lordship.
Now you have promised her to, and that too, like she is your cousin.
Lordship.
She's your cousin sister.
Lordship.
Huh?
Lordship.
She's your cousin sister. You stay in in the same neighborhood. You promised her that I will marry you. Then you did all these things. Then she got pregnant. Then you asked her to like take tablets. Okay, then you take tablets. Then I will marry you. Then she took the tablets.
Lordship.
Then her pregnancy was gone. Then she went to stay with you. We kept her for 4 days. Then after that you have thrown her out. Now you are saying that your parents are not agreeable. How the parents will come?
I'm not saying it is in her statement.
Okay.
Lordship.
Okay. She is saying the parents are not agreeable. But what about you?
Lordship, my submission is that.
No, then you state before this court that you are going to get married to her tomorrow. Then we'll give you bail.
Lordship, one more thing, Lordship. As per the victim's statement, Lordship, the peasant petitioner was 20 years old. Lordship, can you consider that aspect also?
If somebody is 20 years old, then 69 will not come into play?
No, Lordship, I am saying, Lordship.
No, why are you saying so then?
No,
what is see, Mr. Counsel, you argue, you submit whatever you want, but there should be should have some kind of sense. And if you are saying that he's 20 years, she's 20 years of age, 20 years of age is a young girl.
No. Peasant petitioner, as per this victim statement, the peasant
petitioner is 20 years.
20 years. So become the age of the Mary, Lordship is very much is 21 years. So that one ground is also there, Lordship. So my submission is very limited, Lordship. That here in this case, whatever, Lordship, these allegations, Lordship, these allegations, Lordship, there is no pregnancy as per this medical report, Lordship. As per the medical report, there is no pregnancy, Lordship.
The pregnancy is gone, no? The tablets have been taken. Where is the pregnancy?
Lordship, that's why I am saying, Lordship, as per the affair.
No.
She's saying.
Mr. I Hawk, the learned counsel appearing for the accused applicant, also heard Mr. V. Sharma, the learned APP for the state, as well as Mr. N. Jaman, the learned counsel for respondent number 2. This is an application under section 482 of BNSS. No, 482 of, when did you file this?
Sorry, Lordship.
So why write all this? I will not accept this kind of things.
Right.
You file an application under the old sections.
Sorry.
Huh?
Sorry, Lordship, it's mistake.
482 of CRPC. Praying for granting of pre-arrest bail to the accused applicant. No. Application number 482 of the Code of Criminal Procedure, praying for granting pre-arrest bail in connection with Agomoni Police Station case number 130/2025, registered under section 69 of BNS read with section 6 of POCSO Act. Full stop. the gist of the case, as has been narrated in the instant case, is that respondent number two had been respondent number two was involved in a relationship with the accused applicant for last 2 years and had made repeated promises to marry her. On the basis of the aforesaid promises, the informant entered into physical relationship with the accused applicant and thereafter became pregnant. When the same fact was told, intimated to the accused applicant assured her that he will marry her if she gets rid of her pregnancy. Thereafter, the victim girl took certain medicines and got rid of her pregnancy and went to the house of the accused applicant to stay with her. The informant stayed with the family of the accused applicant for a few days, and thereafter the parents and the accused applicant turned her out from their house and refused to marry her. In view of the aforesaid, in view of the aforesaid allegations, the informant has filed the instant FIR. Filed the FIR dated. FIR is dated when?
Lordship,
FIR. What is the date of the FIR? FIR dated
it's not mentions, Lordship.
18/8/2025. 18/8/2025.
This FIR launched before this.
After the investigation. You were in jail for how many days?
No, Lordship, I am not saying.
I'm not in, oh, sorry, AB. Then you write, after registration of the case, the police investigated into the matter and filed charge sheet dated 17/11/2025 against the accused applicant, full stop. The learned counsel appearing for the accused applicant submits that the accused applicant is 20 years of, is a person of 20 years of age, and he and the victim girl were in a love relationship, and he never love relationship, and whatever physical relationship he had with the victim girl was of consensual in nature. He submits that there was no promise of marriage by the accused applicant in the instant case. The learned counsel further submits that section 69 of the the BNS is not applicable in the instant case, and therefore he pays for rearrest bail to the accused applicant. TCR in the instant case has already been received, and the same is produced. Next para. The learned APP opposes the bail application, opposes the bail application, stating incriminating materials available in the TCR against the accused applicant. What is your name? Mr. N. Jaman, the learned counsel appearing for the respondent number 2, has also supported the submission made by the learned APP. Full stop. Taking into after hearing the submissions made by the counsel appearing for the respective parties, and on perusal of the TCR, and having found prima facie incriminating materials against the accused applicant, this court is not inclined to grant any relief to the accused applicant at this stage. Full stop. Accordingly, the instant AB application is rejected.
One observation may be given, Lordship, that Lordship, the court below maybe.
And you can go all the time. Observation is not. You have been practicing for so many years. You know about this. Why this High Court will give an observation?
Lordship.
This is up to you wherever you want to go. Is there any statutory this thing provision whereby High Court needs to give an observation? Then you go and appear there. You may be having chances, but at this stage no.
Alia.
Wait, please, your lord. The anticipated bail petition, my lord, the petitioner of your lordship, is a young female teacher, my lord. The allegation against her, my lord.
Young student?
Teacher, my lord.
Young student teacher. She's a lady.
Young female teacher, my lord.
Now, then what happened?
There is a allegation, my lord. Page 17 is the FIR.
My lord, abetment to commit suicide.
What did she do? What did she do?
She, my lord, what happened? The deceased person, she uploaded one, my lord, one of her photograph and wrote there something with, my lord, abusive words. She posted it in the social media. On finding that, my lord, the petitioner, she called the deceased and her father to
This
school.
is how old she is?
My lordship, class 9,
Class 9 student.
my lord.
And you being a teacher and you use this kind of words.
Not me, my lord.
Who?
It is the student, my lord.
Student.
My lord.
Then?
Against me, my lord.
Then?
Then I called her parents. Her parents came and, my lord, to imbibe discipline, we had, my lord, told her not to repeat such kind of activities in future. She wrote an apology letter to the headmaster and, my lord, she uploaded an, my lord, apology in the WhatsApp also, my lord. The mobile was of her father's mobile where these activities she was doing, my lord. And, my lord, definitely, my lord, yes, my lord, I said that if this kind of things will, in future, it will repeat, then I'll have to file an FIR. And that is why, my lord.
1 second, 1 second.
12 is the FIR.
1 second.
My lord.
Yes.
Then, my lord, I called her parents, my lord, and there was another girl, my lord. Both of their parents were called in the school, my lord. And it is school only, my lord, before the headmaster's office, my lord. We have confronted them, my lord, and given some, my lord, directions that not to repeat such kind of words, my lord. And she uploaded, my lord, one apology letter in the WhatsApp from her father's mobile, in her father's mobile, and, my lord, she wrote an apology letter also to the headmaster, my lord. And I don't know what happened back at her home, my lord, after she went home. On the subsequent day, my lord, she committed suicide. Now, my lord, in this particular case, my lord, definitely, my lordship.
Locker, what is there? Father of the?
And this is after right election, and this is after to upload it, the father done by his father, but both meeting before 24 hours, other I have to inform the police. That is the reason why
Committed suicide. I don't think there is anything heard Mr. M.K. Das. The learned counsel appearing for the accused applicant also heard Mr. P.S. Locker, the learned APP for the state. This is an application under section 482 of BNSS. Sir, अपना ये आगे केस तो 482 CRPC लिखा है ना, ये तो भूल के CRPC लिखा है 482 BNSS लिखा है आगे केस तो ये तो भूल के टाइप करो reason application under section 482 of BNSS 2023 paying for granting PRS bail to the accused applicant in connection with Modern Police Station case number 39/2026 under section 108/3 bracket 5 of BNSS 2023. An FIR was lodged on 17/6/2026 by the informant who is the father. Informant is the mother. Informant who is the informant, the mother of the victim girl, alleging um, alleging that in the suicide of her daughter, her minor daughter, on 16/6/2026, the involvement of Sri Lalit Sunwal and his daughter Srimati Banasri Sunwal,
Vibhasri, ma'am.
Vivasri Sunwal, and the assistant teacher of Bamunbari High School, Srimati Chandani Pradhan, who is the accused applicant in the instant case. On receipt of the FIR, police registered Modern PS case number 39/2026. 26. Full stop. The learned, Mr. M.K. Das, the learned counsel, appearing for the accused applicant, submits that the accused applicant is a Hindi graduate teacher in Bamunbari High School and the victim girl is her student. He submits that there might have been certain misunderstandings, and due to which the victim girl had posted certain defamatory or obscene languages against the accused applicant in a WhatsApp group. Full stop. After coming to know of the aforesaid message, the victim girl was called by the headmaster.
My lordship.
Headmaster called by the school authorities on the next day, and the victim girl had apologized before the school authorities. Accordingly, the victim girl had in fact written an apology letter, which was posted in the which was uploaded in the WhatsApp group through the mobile phone of her father. He submits that the accused applicant is no way connected or involved in any kind of abetment of suicide as alleged in the FIR. Full stop. She submits that after the apology by the victim girl, what had happened back home, it was not known to the accused applicant. He further submits the accused applicant is a teacher and a law-abiding citizen and shall fully cooperate with the investigation. Therefore, he pleads that the accused applicant should be granted pre-arrest bail by this court. And the CD in the instant case has been received. The learned Mr. P.S. Lockout, the learned APP has opposing or what? Has submitted that the investigation is going on in the case, and at this stage the pre-arrest bail, if the pre-arrest bail is granted to the accused applicant, the investigation may get hampered. Next para. This court has heard the submissions made by the counsel appearing for the respective parties and has also perused the materials available in the case diary, taking into account the entire facts of the case as well as materials available in the case diary. Is of the considered opinion that at this stage the accused applicant should be granted the privilege of pre-arrest bail. Accordingly, it is directed that in the event of arrest of the accused applicant by the arresting authority in connection with Modern Police Station case number 39/2026, she shall be released on bail on furnishing of bail bond of rupees 20,000 with a security of the like amount to the satisfaction of the arresting authority subject to the condition that the accused applicant shall appear before the arresting authority within a period of 10 days of passing of this order and shall cooperate with the investigation. Full stop. In terms of the aforesaid direction, the instant AV application is disposed of as allowed.
Deeply obliged. My lordships, in fact, defined reported judgment is also there on
Hmm?
306.
Hmm?
My lordship's judgment is also there, reported, my lord, 306 matter only, wherein my lordship has passed the charge framed under section 306. My lord. Deeply obliged.
55. Your lordship.
Yes.
Here, my lord, the petitioners, my lord. Here, my lord, the contractors, my lord, they work under the Oil India, my lord.
Hmm?
They work under Oil India, my lord.
Hmm.
Some persons, they often disturb them, my lord. We have lost an affair earlier, my lord, though it was not raised, but it was received. And on the allegation of, my lord, assault, my lord, there may not be any injury, my lord, and all the other co-accused, my lord, they granted bail, my lord, pre-arrest bail, my lord. So there is no injury as such, my lord. My lord, may I, if lordship's kind permission, my lord, if lordship's allows, my lord, that there are some orders of the learned session judge, my lord. It clearly reflects that paragraph.
I mean, the co-accused, some co-accused.
Co-accused.
The injury is not there.
No injury, my lord. My lord, if may I produce, my lord.
That's fine, that's fine.
I'll recommend. I'll keep it.
Anything there, you see? Some assault and all this, eh?
Paragraph 8 is all the orders, my lord, paragraph 8.
No injury.
All the orders are the same.
You have a look into this. These are all co-accused.
Co-accused, my lord, co-accused. No, actually, my lord, they do drilling works, my lord, under Oil India, they disturb. We have lost an affair, it was not registered.
Okay, heard Mr. SM Abdullah P, the learned counsel appearing for the accused applicant, also heard Mr. PS Locker, the learned APD for the state. This is an application under section 482 of BNSS, praying for granting pre-arrest bail to accused applicants in connection with Barekuri PS case number 7/2026 under sections 109/117 in bracket 2, /118 bracket 2, /190, /190 bracket 2, /191 bracket 2, /191 bracket 3, /296, /351 bracket 3 of BNS 2023. An FIR was lodged on 30/5/2026 by one Himadri Dahotia Chetia before the officer in charge Barekuri Police Station, alleging inter alia that on 29/6/2025 at around 8:30 p.m. the accused Jogendra Mohan and his companions abused her husband, brother and mother and father-in-law at their Katwal village in front of the Rig Oil India Limited. It was also it was alleged that they used filthy languages, and the accused Subrajit Sutia, Maimon Moran and others brutally assaulted them with sharp weapons, causing grievous injuries on various parts, causing grievous injuries. Due to such assault, the informants, the informants, husband, brother, mother, and father-in-law were required to be taken to the hospital for medical treatment. On receipt of the FIR, police on receipt of the FIR, police registered Barekuri PS case number 7/2026 under the aforementioned sections. Mr. Abdullah, the learned counsel appearing for the accused applicant submits that after filing of the FIR, the police is visiting the visiting the residence of the accused applicant, and he apprehends, he seriously seriously apprehending arrest in the instant case, and therefore filed this instant anticipatory bail application. He submits that the allegations made in the FIR are not correct, and in fact, some fight had occurred due to certain misunderstanding regarding allotment of certain contractual work uh, uh, at the site of the rig of the Oil India Limited. He submits that the fight was not intentional, and the injury alleged to have been sustained by the informant's family members are incorrect, are not of serious nature. Full stop. He further submits that certain co-accused who have been given bail.
Three co-accused, one, two others before your.
Okay. Three of the co-accused in the instant case have already been granted bail pre-arrest bail by the additional session judge in bracket FTC Tinsukia, wide different orders. Same day.
No, but
Different orders.
Same day, man, same.
By different orders on the same day, that is on 23/6/2026. He submits that the accused applicant is a villager. Accused applicants are villagers and law-abiding citizens, and shall fully cooperate with the investigation in the instant case. Next para. On the other hand, the learned APP. What is there? Learned APP opposes the bail of the accused applicants, submitting that there are materials suggesting involvement of the accused applicants in the offense that has been narrated in the FIR. The CD in the instant case has been produced, and the same has been perused. Full stop. After hearing the learned counsel appearing for the respective parties, this court is of the considered opinion that the accused applicants should be granted pre-arrest bail at this stage. Accordingly, it is directed that the accused applicants shall be released. It is directed that in the event of arrest of the accused applicants, they shall be released on furnishing of bail bond of rupees 20,000 each with surety of like nature, to the satisfaction of the arresting authority in connection with Barakuri PS case number 7/2026, subject to the following conditions. That the accused applicant, number one, accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order. Number two, the accused applicant shall fully cooperate with the investigation and shall make themselves available as and when called for by the investigating officer. Number three, the accused applicant shall not try to influence any of the witnesses that may be involved in the instant case. Full stop. Next, in terms of the aforesaid directions, the instant AV application is disposed of as allowed.
Like.
56.
FIR, your lordship will find at page 11% at page 18, lordship. The petitioner before your lordship is a computer assistant working under PNRD department, lordship.
Page 18, date of lodging of the FIR, Lordship may kindly note. Page 18. Date of lodging of the FIR, date, page 18.
Page?
18, one.
Yes.
In top portion, date is there, 26, that was overwritten. Why it is overwritten, I will place before Lordship. May I read the-
Page?
Page 18.
18. Yes. What is IAY wage bills?
Indira Awas Yojana.
Okay.
That was Lordship renamed and Lordship.
Okay, one second. Okay, this needs investigation. What is your case?
My case is.
Why it should be granted?
No, in
Because
Lordship-
investigation is required in this case, and this kind of, I mean, issues are not healthy for the society.
No, Lordship may kindly see my role, Lordship. What I am.
Yes, what is your role? You are,
Yojana was
Huh?
Lordship renamed in the and reconstituted in the year 2016 from 1st April.
although Sri
As-
Tanu, let me read, although Sri Tanuj Sunwal was no longer officially working in Bogiville Gaon Panchayat from December 2025, another computer is appointed. It has been found that the online processing records of Bogiville Gaon Panchayat continued without the knowledge and authorization of the concerned Panchayat officials and staff members. What
Now,
does it
Lordship-
mean?
Now, Lordship may kindly see page 21.
Hmm?
Page 21. This
That
letter
next,
is-
next para implicates you directly.
No,
During
the-
social
my
audit,
submission
no,
to
no,
your
no,
Lordship
listen,
is
listen.
FIR
During the FIR seriously implicates you.
Yes,
You are saying your involvement is not there. Now you show the
page
form,
21.
page 21,
Page
yes.
20.
Hmm.
How they came to know that I was the person who uploaded those documents.
Hmm.
Because page 21 clearly says
Hmm.
that the password of the computer is used by many computer assistants. Lordship.
Hmm. I
And it
respect,
cannot
please,
be asserted
one
to
second,
an-
one second. Okay,
Now,
then,
now page 22, your Lordship will find that subsequently GP secretary, accredited engineer and GRS, they wrote a letter to BDO saying my name on the very next day. And from that, Lordship, my name came up.
Yes.
If they says my name, Lordship, because
no,
Lordship.
correct, there is some suspicion that
No,
your
on
suspicion
what
about your involvement.
No, on what basis they have named me, only that much your Lordship will see, because Lordship, they are the persons who who selects beneficiaries. Accredited engineer is the person who gives the completion certificate. They are the they ought to have been one of the accused person, Lordship. Now, in this regard, Lordship, just I am referring to one judgment of Honorable Apex Court. The Lordship,
On what
yeah.
point, apex code on what point?
Because Lordship, in regarding 161 statement of accused persons who are supposed to be accused, Lordship. That paragraph 53, Lordship.
No, that is fine, that we are aware of.
Lordship. Lordship, may I kindly have a look at paragraph 43, clause subsection subpara 10, Lordship.
And like, what about this letter, 10-6-2026,
They are also, Lordship.
page 26?
They are also page 26.
It has been found that one computer assistant, Tanuj Sunwal, without knowledge, approval, or information of any concerned officials or staff members of the respective Gaon Panchayats, had allegedly generated IAY wage bills. This has been written by the
Video
to the chief executive
The
officer.
information given by accredited engineer GRS. From where they came to know, that part your Lordship.
That will be found out upon investigation.
So if they
That
have-
cannot be found out by this court, neither by you nor by this court.
if-
That can be found out only after
Only
investigation.
One aspect I am submitting to Lordship, that if they are naming me as an accused,
Hmm.
on what basis they have said so?
They
Only
say
that-
so because you have the, because you have unauthorizedly used this.
No, I am not the only person who used the computer, Lordship. That is reflected in paragraph 20, page 21 itself.
Mr. Bhattakur, what is there in there? But he's basing his argument only on that. Hmm. 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 So this happened earlier or what? So he has given benefits to some those people's twice. Close and so he did this before joining of this person. Huh? The other person, right?
The present petitioner joined in the year 2000.
No, Bornali Ian written on 462026. And the allegations of these transactions for which is the time period of that?
That time period is not mentioned. It is said that houses were completed in the year 2017. I joined as a computer assistant in the year 2020, Lordship.
Correct. So is there any mention of the time? Okay, 21, yes. Hmm. Hmm. Hmm.
During her tenure.
Correct. Then what happened? Yes. Hmm. Hmm. Okay, wow. Is there any other material in your CD? Hmm.
Only that much, Lordship, if they name me, that paragraph 53 and
It will be difficult, Mr.
May I kindly have a look for a moment, that paragraph of Honorable Apex Court, because they are the persons who signed those documents, Lordship. If they are one of the accused, Lordship, their statements cannot probably cannot be relied in the stage of anticipated bail also. That is what Supreme Court says, Lord. Because how they came to know my name, because if you are now, Lordship, may I kindly see paragraph 28. Initially, they filed an.
Okay, we will not take their consideration, but like prima facie, this court is convinced that there are some materials against you, and we are denying this. The 161 statement, Supreme Court's observation that those things are perfectly fine. We are totally agreeable with that. But in all the cases, in the preliminary stage of investigation, they come up with that. That's this thing that like he has Yes, LA, so this cannot be considered, will not consider it.
I am on, not on.
We will not consider
Lordship,
it.
may I kindly say page 20.
Will not consider it.
Page
I'm
28.
convinced that like there are certain prima facie materials against you and like we will not allow you to go on bail.
No,
in
Lordship,
these
may I
days.
kindly say page 20.
No, no, I will
This-
not see
this- this
anything.
page is
No.
also relevant because the original FIR was misplaced. Whose name was there, who was those accused persons initial state?
See,
Lordship,
this
may I-
FIR was filed on the basis of a letter, right?
So that initial
No,
FIR
no,
was misplaced.
then,
That is the report of the IO.
correct, maybe, but whatever, which was is the FIR of the,
Lordship, may I kindly say page 20.
the FIR was filed by the BDO, right?
BDO.
Hmm. The 26/6/2026.
Yes, 26/6/2026, but
Hmm.
he was directed to be filed
Hmm.
by the CEO
Hmm.
on 15/6/2026. That page 27 your lordship will get. And therefore I have pointed out the that portion where overwritten is there in page 18.
Where is overwritten?
Page date your lordship, may I kindly say page 18.
Huh?
In date lordship, it is overwritten.
26/6/2026 is there.
That 2 is overwritten lordship. And some main FIR was not was misplaced, which is admitted by the IO, and it was written a letter to the Chief Judicial Magistrate also, lordship.
How that will make a difference?
Because lordship, that official witnesses are also involved, lordship.
Hmm?
They are the persons who signed those documents, and now they have shifted the blame entirely to the present petitioner, lordship. And in fact, lordship, that page 21 also says that all the uploading was done during her tenure without her knowledge. I was not there. Page 21.
No, not hurt in here.
Yes, it is there, lordship.
No, not hurt in here.
No, lordship, may I kindly see on June 2nd June 2026, during the social
Social audit, it came to my notice. Several I have waste demands and letters have been made
during my tenure.
tenure without my knowledge. This is one of the things.
Yes.
Then what about other things? That's why I joined my duties on so and so 5 December 2025. Prior to my joining, so and so was holding the dual charge of Bogeyville so and so. Then it is part in, oh yes, this was filed on 4/6/2026.
Yes.
Then FIR was filed on when?
No, before that, lordship, page 22 on 5/6/2020, they named me without any inquiry, without any, on page 22.
Page 22.
Yeah, on 5/6/2026, they
Hmm.
named me.
They're saying that it came to know to our notice.
Yeah.
I mean, you have not been convicted. They have just saying that you have come to notice.
So if the password is used by many persons, lordship, how they came to know that I was the person who uploaded? They have not made any inquiry, lordship. That is my case, lordship, because on till 4th, there was no person who uploaded those documents.
This has come from the GP secretary.
Yes.
GP secretary.
Accredited engineer and GRS. They are the
GRS.
persons who lordship selects the beneficiary and gives completion certificate. And even in fact, they have not said that their signatures are false. No statement is there in their letter. Nothing has been mentioned. And without completion certificate issued by the accredited engineer, that amount will not be disbursed, lordship.
What about this 10/6/2026 letter?
10/6 lordship, BDO, because all the information was given to BDO.
No, it was given to the BDO by who? By Secretary
Yes.
Bogeyville Gram Panchayat.
They are also members of that Gram Sabha, lordship, who selects the beneficiaries. No person says that their signatures were false. Nowhere it is mentioned, lordship. And on the basis of their statement that lordship, BDO has informed the CEO about my name. No independent inquiry was conducted. If lordship, they have found any.
Now, where is, from where you are saying that like FIR was missing?
That page 28.
Page 28?
This is the letter written by the IO to the Chief Judicial Magistrate. for
One
delay-
second.
Delay in sending the original FIR. See, he has not been suspended by the department till date. If any inquiry was conducted, if anything found.
No, it says that however, due to an inadvertent clerical mistake, the original FIR was mistakenly misfiled in the records of Barbuda Police Station and therefore could not be forwarded to the Honorable Court. within the prescribed time. That during the checking of the police station records, the said original, it was traced.
It was traced,
Then-
subsequently, they have said it was traced, but within.
I mean, by that time, more than 24 hours. So he is giving an explanation why it was not forwarded. So original FIR is there. It has been traced.
They have
The
said-
contents are same. You can't say that like original FIR, the contents were different and this FIR contents were different, same FIR.
Apex court said, subject to what your lordship finds person, that whenever any FIR is filed, that it has to be immediately sent to the police.
Correct. That's why they,
Some checks can be there.
that is why the explanation has been given that it was misfiled. And accordingly, when it was traced, then like there was some delay and then like they were asking for a condoned, that delay to be condoned. That is what.
That I leave up to your lordship, but on the other hand also, lordship, if they have found any, made any inquiry, they have found material against me.
No, there are,
Let me, lordship.
Mr. Ahmed, anyways, I've heard Mr. A. Ahmed, the learned counsel, appearing for the.
That is my submission.
Hmm?
He will lose his job, lordship. Computers, other persons are, lordship, they are of the main person, they have nowhere say, lordship, they have made an inquiry or their signatures are false. Only to that extent I am paying, lordship. If all are documentary evidence, lordship.
Heard
Your
Mr. A. Ahmed, the learned counsel, appearing for the accused applicant. Also heard Mr. P. Borthakur, the learned APP for the state. This is an application under section 482 of BNSS 2023, praying for granting bail to the accused applicant in connection with Borbora Police Station case number 43/2026 under sections 316 bracket small 5 stroke 313 bracket 4 stroke 336 bracket 2 stroke 340 bracket 2 stroke 61 bracket 2 bracket small a stroke 3 bracket 5 of BNS read with section 13 bracket 2 of Prevention of Corruption Act 1988. The gist of the case, as has been narrated in the FIR, and that on 26/6/2002 FIR dated
26/6/2020.
26
6/2000.
26/6/2026 that serious financial irregularity and suspected misappropriation of government funds by the accused applicant, who was engaged as a computer assistant in Bogibil Gaon Panchayat and Dulia Kakoti Gaon Panchayat. The aforesaid allegations of financial irregularity have come to the light during the social audit and subsequent departmental verification of records. It was alleged that unauthorized Indira Awas Yojana wage bills were generated in the names of beneficiaries whose IAY houses had already been completed and closed in the year 2017. Accordingly, it was suspected that financial irregularity to the tune of rupees 40 lakhs is involved in the instant in the case. The learned counsel, Mr. A. Ahmed, the learned counsel, appearing for the accused applicant, submits that the FIR has been lost and the lost against the accused FIR has been lost and the accused applicant has been named as an accused in the FIR without any basis and without any proper verification of the documents and facts. He submits that the accused applicant was he submits that though the accused applicant was working as a computer assistant at some point of time, there is no material to suggest that the accused applicant has committed any financial irregularity. He submits that while referring to the document dated 4/6/2026 written by one Bornali Yen YEIN to the BDO, he submits that there is a specific there was a specific intimation that 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 since since the password of the computers used are available with other persons or other computer assistants also, it cannot be specifically said as to who had committed the financial irregularities. Full stop. Is the learned counsel further submits that the accused submits that the complaints that have been filed by the officers of the Gram Panchayat are in fact are those persons who have submitted or who has verified the applications for applications for IAY, and there are all possibilities of their involvement in the financial irregularities also. Therefore, he submits that the accused applicant, being a government servant is a responsible person and shall cooperate with the investigation in the case. Full stop. Mr. P. Watercourt, the learned APP, on the other hand, submits that there are sufficient incriminating materials against the accused applicant of his involvement in the incident case. Full stop. The CD in the incident case has been produced before this court, and the same has been produced. Taking into account the materials available in the case diary and the allegations as have been made in the FIR, this court is of the considered opinion that this is a fit case wherein the accused applicant should be granted the privilege of anticipatory bail. Accordingly, it is directed that in the event of arrest of the accused applicant in connection with Borborua Police Station case number 43/2023, he shall be released on furnishing of a bail bond of rupees 30,000 with a security of like nature, subject to the satisfaction of the arresting authority, subject to the following conditions. Number one, the accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order. Number two, the accused applicant shall cooperate with the investigation and shall make himself available as and when required by the investigating officer. Number three, accused applicant shall not try to influence any of the witnesses that may be involved in the incident case. Next para, in terms of the aforesaid direction, the instant AB application is disposed of. As allowed. What? Mr. Sharma, you have gone through the petition? Petition has been given to you? Oh, you haven't gone through? You have gone through, I know it.
My lord, one thing before I start of the case, please see the statute under the Assam Minor Mineral Concession Rules. Assam Minor Mineral Concession Rules 2013. Please see that first.
Tell me one thing, 61-2-3165-3183.
This is a cheating and my lord, criminal breach of trust.
Yes, a cheating and criminal breach of
Now
trust.
I will show it. Why I'm showing that this is at all is not, doesn't lie also. In view of 72. See 72 of the Assam Minor Mineral Concession Rules. 72 rule. Lordship got it? Any rent, royalty, fee, contract money or other sum due to the government or penalty imposed under this rule or under the terms and condition of the mining lease or contract or permit and remaining unpaid shall constitute a charge on the assets of a mineral concession holder or the security furnished under this rule and shall be recoverable as areas of land revenue. So where is your, my lord, you can lodge an FIR. These are mere an employer of a company. They are working as an employer. One is a project manager and one is, my lord, a general manager of the company. And there is, my lord, what is the case about? There are three contracts, three package 1, package 2, package 3. Where so one part of state of Arunachal Pradesh it falls and rest 2 part for the state of Arunachal. Sir, project 1, project 2, I'll show it that 100% completed. Now the forest royalty, which is paid to the state of Arunachal Pradesh, it is about 13 crores has been paid. So far as state of Assam is concerned, it is about 87 lakhs has been paid. Now they comes up with notice and saying the additional 22 crores has to be paid. Now, which is now being put to challenge. Today we have filed a writ petition which is serial number 8176 of 2026. Before this serial number 8176 of 2026. 8176 of 2026. We are challenging this notice of 22 crores. How can you impose it 22? That's one of the separate aspect. But
yes, I'm protecting you. Like I have gone through this. Mr. Sarma, you tell me how these sections are, applicable. FIR is not there. You are not giving that FIR. The contents are there. No, we have, I have gone through it. Mr. Sarma, there is some liabilities. Perfectly fine. There may be some liabilities. There may be some forest liabilities. And only because there are some forest liabilities, can you file an FIR just like that and pressurize him to pay it? Can it be done? So you can come up with your, this thing, but like at this stage, we are going to protect him. Then I have gone through it and I'm convinced that this is a case where the person should be protected because forest royalty is supposed to be given. Forest royalty, how forest royalty used to be paid, how it can be recovered, all of their procedure is there. But how the case of cheating and all these things has come, and that too, forest royalty was paid once, and you are asking for some additional amount. There were some meeting held. In the meeting, it was assured that within such and such time, we are going to pay it. We'll assess it and we'll pay it whatever is required. And in spite of that, you are pressurizing him. How can you do that? No. Then you come to that. Come to this this page. Come to this this. Come to this. Come to page 15. First, you come to 15. What is this? Annexure 2. This said of his memorandum. Okay. It says minutes of meeting regarding deposition of forest royalty related to so and so. So there is no dispute about this. This is regarding my forest royalty. Then you come to please find enclosed here with minutes of meeting held in the office of general manager in bracket P NHI DCL so and so 87 so and so represented the divisional forest officer so and EPC contractor to discuss. So this is correct. Now you come to the minutes of the meeting. So a meeting was held on 8/7/2026, correct? Then in the office of the general manager P so and so at the outset GM NHI DCL inquired regarding the status of the forest royalty due to the forest department by EPC contractor for projects that are being executed by so and so. Okay. Now, representative of the APC contractor apprised that the materials are being sourced from the state of Assam as well as state of Arunachal Pradesh, and part of the project stretch is also passing through Arunachal Pradesh. Accordingly, forest royalty amount is being assessed by them and same shall be deposited with the forest department at the earliest. There is some commitment, correct? The representative of the forest, the divisional forest officer Dhemaji has requested that the due forest royalty shall be deposited by the EPC contractor to the forest department on immediate basis. In this regard, GM so and so NACL intimated that as per contract agreement, this is the liability of the EPC contractor. Now, GMP NACL further directed the EPC contractor shall assess the royalty amount in consultation with the forest department, and the requisite forest royalty shall be deposited within a period of 7 days. So this meeting happened on when? 8/7/2026. So 7 days already has been agreed. So 7 days means the 15th, the date is there. So now Now, the FIR has been filed.
There are 4.5. 4.6, can you see?
There are 4.6.
Yes, please see 4.6.
That suddenly on 10/7/2026, while the applicant and his so and so, so and so, so and so, so and so, he has been special task force arrived at the office and illegally, unlawfully took the applicant in his colleague custody, and they have taken him to Gauhati, it seems, later on 10/7, and they have been released. Then they have been issued 35(3) BNSS notice. But this, no, you are correct. The FIR is not there, so we cannot ascertain the fact. But these documents are not incorrect. So if the documents are not incorrect, and where is the thing that, like, I mean, there is any kind of. No, that is then that we'll find out. That we'll find out when you come up with your instructions. Will come out. But prima facie, I don't think like there is the minutes is there. Minutes is there. So we'll give you 1 week time, then till that time they'll be protected. You can bring it. I mean, when do you want it to be fixed?
After a week. After a week.
Huh?
My lord, after a week, let it, my lord, what is the position my learned friend is saying now? They are standing outside my house. My learned friend doesn't know. This is what the authority is doing it.
No, I mean,
I'm very sorry to say.
we are little bit perturbed by
This is
only
what
one
I am
thing.
sorry to say.
Since the DFO was there, NHIDCL official was there, this EPC contractor representatives, both are the company employees, they were there. And there was an minutes of the meeting which has been signed by everyone. Then I do not know why the FIR has been filed. And correct. So, but at least prima facie, I mean, since the FIR is not with them, 35(6)(3) notice has been issued. They have some apprehension, and and they have been allowed to go.
Yeah,
No, they have
I'm
been
sorry.
they have been brought in from there to Guwahati also.
Yes.
Because there was some interrogation took place. Then they have been, I mean, some inquiry is going on. So they are apprehending. So what I am doing is, Mr. Sharma,
One last.
by Monday you bring this case diary, and till that time we will protect it. Okay. And he can, I mean, when you are supposed to.
I
No.
will go to their place and cooperate with the investigation.
Correct. You go and we cooperate
within
with the
next 3
investigation.
days I will go.
We'll ask them to cooperate with the investigation. See, there was a 35(3) notice to appear, asking them to appear. I think it was today only.
Today,
Today.
2 o'clock.
It-
Saturday.
No, tomorrow it may be difficult. I mean, today it is.
No, they harm is that you arrest me, then thereafter you'll say go before a criminal court. They are waiting outside my house. No, please. they are waiting
Okay.
outside
So you are saying that you can bring the case there when tomorrow, but like we are fixing it on 16th. 16th. Till 16th you'll be protected. Let us see, because only thing is that, like, you see, Mr. Das, only thing is the problem is that FIR is not there.
No, I know very well. If he doesn't, what they have done, please see 4.9. My learned friend doesn't know. That's why please see 4.9. Please, my lord, your lordship will kindly read 4.9. What they are saying. This is the way. This is a big company. I am giving particular work to your state. And you are asking this amount and saying if you don't pay these 2 crores, then we'll lift you up. That's what they are trying to do it. Well, what occasion to
See,
come
4.9,
to our court?
4.9 is.
Why will come to the
See,
court?
this is on affidavit.
700 crores, my lord. A project has been given
See,
by the
this
state.
statement has been made on affidavit.
700 crores.
Okay, heard Mr. D. Das, the learned senior counsel, assisted by Mr. K. Talukdar, the learned counsel for the accused applicant. 1560. 1561 or 60?
2F.
No, this has been wrongly written here. The 1561 লিখছে বুঝছো এটা কারেক্ট করে নেব এটা ভুলকে লিখছে না 1561 এটা 1560 লিখছে কারেক্ট করে 1560 easy also লিখো is an hard দিলা না and also Mr. B. Sharma, the learned APP for the state. This is an application under section 482 of BNSS, praying for anticipatory bail to the accused applicant in connection with the FIR, in connection with the Special Task Force PS case number 4/2026 under section 61, registered under section 61(2)/316(5), 61(2), 61(2), 316(5), 318(3) of BNS 2023. Mr. D. Das, the laureate's senior counsel, appearing for the accused applicant, submits that the applicant is presently working as a deputy project manager. Manager in Messrs. Kaluwala Constructions Private Limited, based out of Kaluwala Constructions Private Limited, a company incorporated, the company having its registered office at Gurgaon. He submits that the company the company of the accused applicant is executing a highway project in Dhemaji district in the state of Assam. He submits that the company is executing the work as the contract for the work was awarded by National Highways and Infrastructure Development Corporation Limited (NHIDCL) under the EPC model. He submits that during the execution of the work, since earth is required for construction of the road, the earth was procured, and accordingly, the required forest royalty have been paid by the company to the Forest Department of Assam, and accordingly, they have been issued forest royalty clearance certificate for both the state of Assam as well as the state of Arunachal Pradesh, as certain portion of the work is being executed in part of Arunachal Pradesh also. He submits that approximately 20 crores of royalty of forest royalty have been has been paid to the Forest Department. 22 crores alone to Forest Department?
No, additional claims they have made. 22 in addition. We paid
correct. What was the last line? No. Cut that. He submits that he submits that in addition to whatever the forest royalty that has been paid, already paid, the forest officials, presently making certain additional claims of forest royalty to the tune of approximately 22 crores, purportedly under the provisions of the Assam Minor Minerals Concession Rules 2013, read with Assam Minor Mineral Concession in bracket amendment bracket complete rules 2021. He submits that in view of the aforesaid demand of additional forest royalties, certain meetings have already amongst certain meetings. No, right. One meeting dated 8/7/2026 among the officials of the NHIDCL, Forest Department, as well as the EPC contractor, that is the petitioners, that the accused applicant's company had taken place, and in the aforesaid meeting, it has been decided by all the all the parties involved that the required for forest royalty would be assessed by the company of the accused applicant in consultation with the forest department, and the same will be paid within a period of 7 days. Full stop. He submits that in spite of the aforesaid understanding by the member by the minutes by the office memorandum dated 8/7/2026 all of a sudden the
You were brought to Gauhati.
all of a sudden the police
10/7/2026.
all of a sudden on 10/7/2026. No, prior to that also, I mean, all of a sudden on 10/7/2026, the applicant along with another person, namely another colleague, namely Sri Pradeep Kumar Bhattacharya, who is also an employee of the same company, of the aforesaid company, who has been working in the project monitoring unit, detained by a team of special task force, and thereafter demanded certain information and documents, information like documents, receipt certificates pertaining to payment of the forest royalty. He submits that the accused applicant along with his colleague had duly complied with such demands and submitted the aforesaid information and documents to the task force. He submits that in spite of the compliance of such demands at around 5 p.m. on at around in spite of the compliance, the applicant and his colleague were brought to the office of the respondent at Gauhati at around 11:40 p.m. on 10/7/2026 by the special task force. He submits that the the accused applicant and his colleague were illegally detained and kept in custody by the Special Task Force. And finally, they have been handed over a notice dated 11/7/20. Finally, at around 5 p.m. on 11/7/2026, they have been handed over with a notice dated 11/7/2026 issued under section 35(3) of BNSS, requesting them to present before the respondent authority on 13/7/2026. Full stop. The learned senior counsel submits that the special task force have been constantly demanding the accused applicant for payment of an amount of Amount of 2 crores or 22 crores?
2 crores first.
Huh?
2 crores immediately. 4.9.
Okay, demanding an amount of rupees 2 crores immediately out of the additional out of the demand of rupees 22 crores
Yes.
for a forest royalty. Full stop. The learned counsel appearing for the accused, he further submits that as far as forest royalty is, as far as recovery of forest royalty is concerned, there is a laid down procedure available in Assam Minor Minerals Concession Rules, 2013, and the forest department, if so required, needs to follow the aforesaid provision for recovery of any forest royalty. He submits that the action of the special task force in detaining and bringing them to Gauhati and thereafter releasing them and issuing of notice under 35(3) in bracket 3 of BNSS is not warranted, full stop. He further submits that he submits that in spite of their best efforts, they could not gather a copy of the FIR in the instant case. However, from the notice that has been handed over to the accused applicant, it seems that Special Task Force PS case number 4004/2026 was registered under section 61 in bracket 2/316 bracket 5/318 bracket 3 of BNS and he submits that these sections are not applicable to the instant case at all. As the issue involved in the instant case is regarding recovery of forest royalty. Full stop. He further submits that as far as the demand of the additional forest royalty is concerned, the accused the company of the accused applicant has already filed a writ petition before this court challenging the aforesaid demand, additional demand. Full stop. He submits that due to the facts as narrated above, the accused applicant is seriously apprehending arrest in the instant case and therefore prays for protection from this court. Also. Next paragraph. Mr. B. Sharma, the learned APP, on the other hand, opposes any interim relief to the accused applicant in the instant case. He submits that since the copy of the FIR is not available on record, without perusing the FIR, it cannot be ascertained as to why the special task force has been constituted for the instant case, and what exactly is the issue involved. Therefore, he prays that the interim bail prayer of the accused applicant should be considered on perusal of the case diary. Full stop. Next paragraph. Taking into account now after hearing the submission made by the counsel appearing for the respective parties, and taking into account the entire facts of the case, especially considering the fact that the case seems to be involved, the issue seems to be of recovery of forest royalty and forest royalty and also forest royalty, and also due to the fact that there was a minute of meeting which recorded that which recorded the agreement of the company of the accused applicant that forest royalty, if there is any, shall be assessed jointly with the forest department, and thereafter same will be paid in a short span of time.
If at all.
If at all
Is due.
if at all due, shall be paid in a short span of time, comma, is of the considered view that at this stage the accused applicant should be protected, full stop. Accordingly, it is directed that in the event of arrest of the accused applicant by the arresting authority in connection with he shall be released on furnishing of a bail bond of rupees 50,000 with a security of like nature to the satisfaction of the arresting authority, subject to the. You appear when
Within 3
Huh?
days, in 3 days.
subject to the condition that the accused applicant shall appear before the concerned respondent authority within a period of 3 days from passing of this order. It is also directed that the accused applicant shall fully cooperate with the investigation and make himself available as and when called for by the accused or called for by the investigating officer. Then you write next para you write call for the CD. Let the matter be fixed on.
Let it be Monday, I think next Monday. He'll get time also to cooperate with the.
And he's saying that he's going to bring
I
it.
just requested him, it's up to him now. No, you do it. No, you do it Friday, no problem.
Let it fix on Friday.
I can make a request. If he doesn't agree, then it is okay.
Let
Friday,
them
it be Friday.
have some breath.
Friday. Fine.
Eh? I understand that. We understand that. But at least give him some space to breathe and all. Okay. Anyways, like we'll fix it on Friday.
This Friday? Yes.
Let the matter be fixed on 16th. 17th. 17th. 17th at 2 p.m.
No problem.
2 p.m.
No
17th at 2 p.m. 2 p.m. Same order, no? The other one is another case.
Only difference is the general
second matter. That position to বেলেগ হ'ব ইয়াত ভিতৰত তাৰে ইয়াতে general manager. Mr. Pradeep Kumar Bhattacharya is general manager. The other one was project manager. Deputy project manager. So same orders. Interim bill. তারা লিখিছো না রিলিজ কৰি দিব কাৰণে ইন্টারিম বিল বুলি দিবনে ইন্টারিম বিল লিখি দিব So we can call for the CD. CD part of the TCR. Hmm? Okay, heard Mr. B.A. Chaudhary, the learned counsel appearing for the petitioners. Two cases are there, no? Petition.
Petition 1443.
1443, yeah. For the petitioners. Also heard Mr. B. Sharma, the learned APP for the state, as well as Mr. D. Bora, the learned counsel appearing for respondent number 2. The learned APP, huh? The learned APP submits that though the TCR though the scan copy or what? Though the scan copy of the TCR has been received, the same does not contain the CD part of the case. CD part of the case, and he submits that the CD part of the case will be required in the instant case for proper adjudication. In view of the aforesaid registry to call for the CD part of the TCR from the court of the CD part of the TCR of PRC case number 700/2024 from the court of the learned Chief Judicial Magistrate, Kamrup Metro, Gauhati. Full stop. Right? No, like we'll pass separate order. Let the matter be listed on after 4 weeks. After 4 weeks, and in this matter, other matter, you are the respondent number 2.
In item 30, the interim may kindly be continued.
Interim order so passed earlier shall continue. In both the orders. And in this matter, I mean, you are the respondent number 1.
In 30.
Then you write that they heard Mr. D. Bora, the learned counsel appearing for the petitioner, and also heard Mr. B. Sharma, learned APP, as well as Mr. V. A. Chaudhary for respondent number 2. Then you can write, I mean, it's not required to be separately called. So we can only write that this case should be listed with this.
Here also statements are not.
Okay, or separate, no. Correct. The registry to call for the CD part of the TCR in connection with, which is the case number? PRC number 584/2024 from the court of the learned Chief Judicial Magistrate, Kamrup Metro. Let the matter be listed along with the earlier matter. That write that number on the same date after 4 weeks. After 4 weeks.
There is the interim order.
Interim order also same interim.
Of less.
Okay.
57 orders.
May it please your lordship. Lordship,
What happened? What was the mistake?
Lordship, for inadvertence of the counsel, like our junior counsel, your lordship, the liberty to refile was not printed in the order copy, your lordship.
Order has been passed already.
Lordship, but this has prejudiced the petitioner inadvertently, your lordship. They are now unable to refile it, your lordship, whereas the withdrawal was done just to refile, lordship, so that the correction can be done, your lordship. So this is frustrating the purpose of withdrawal, your lordship.
Heard Mr.
I.S. Mazhar Bhuiya, your lordship.
N.S. Mazhar Bhuiya.
I.S. Mazhar Bhuiya.
I.S. Mazhar Bhuiya, the learned counsel appearing for the applicant. The instant application also heard Mr. J. Hendick, the learned government advocate, learned counsel appearing for the respondents. Or what? All the respondents. Mr. J. Hendick is a government advocate or what? Standing counsel will write standing counsel for the revenue department. Full stop. Then you write this instant application has been filed for correction of
Page 10, your lord.
Correction of but you have given this of page 16. Where is the other order?
Lordship, last page, page 21.
Filed for correcting a small error that has occurred in the order dated 26/5/2026 due to the inadvertent error committed by the counsel appearing for the petitioner. Petitioner, full stop. The learned counsel appearing for the applicant submits that the learned counsel, while appearing on 26/5/2026 in WPC number 6477/2022, failed to seek liberty from this court for filing the case afresh while withdrawing the aforesaid WPC number WPC 6477/2022. Therefore, he prays that he prays that the order should be accordingly corrected by giving liberty to the petitioner to file a writ petition again, if so advised. Next, Mr. J. Handick, the learned counsel for the respondent revenue authority, doesn't have any objection to such prayer, full stop. Accordingly, it is directed that in the order dated 26/5/2026, in the last line, in the last line, the term, the word in quotation, you write liberty granted. Liberty to file afresh is granted. Liberty to file afresh is granted. Should be added. Therefore, the order dated 26/5/2026 is modified to the following extent. The last line of the order is modified to the following extent. Then you write, accordingly, the matter is dismissed on withdrawal, with the liberty to file afresh if so advised. Okay. In terms of then you write, in terms of the aforesaid direction, the instant IA is disposed of. It will do.
Great.
Right.
8 minutes, that was a
That is leftover. That will be leftover. I don't know, they have misplaced it.
My lord, I understand that, my lord. There was a e-filing, my lord. The provision of e-filing is there, I suppose, my lord. The provision of e-filing, my lord, both online and offline, my lord. Probably, my lord, that is available, my lord. This petition.
So they will do something, whatever is there, whatever is
My only
necessary.
prayer is that, my lord, lordship will be pleased to, my lord, post it by tomorrow, my lord, if possible.
No.
Because this petition is.
No, that I cannot say that you'll have to talk to the registry then. I mean, like they have misplaced
Just
it.
day after tomorrow, my lord. Day after tomorrow, my lord, if possible.
No, what I'm saying is that they will do it at the earliest. These bench people has come to, they have come to me.
Yes,
They have apologized before me that there was something happened. The person who has gone to give the file, he has misplaced it somewhere. They are trying to get it, but must have misplaced it. Means like they must have given to some other judge instead of, because it was in supplementary thing.
Yes.
So they are trying to do the best to release this matter, and they will do it. They will do it as soon as possible. If they do not do it, then mention. Okay. But you just give them 2-3 days time. 2-3 days time they are seeking. Give them some time.
Because on last occasion, my lord, the last opportunity was given, my lord, to the informant side also, my lord. There was a observation, my lord. I understand, my lord. That.
Can't be held. I mean, the file is, I mean, they are trying to locate it as soon as possible. They'll do it. And if they do not do it by 2-3 days, then you mention. They will do it. Fine. for